to get up and running here, so let's wait for that to happen. What a day yesterday, if you missed it. What an absolute day of days. My name is Grant Smith Ellis. It is Wednesday, November 26, 2025, just after 8 a.m. Eastern. We're on time before we do anything or talk about yesterday's chaos, the war to settle the score in front of Dedham District Court at Kate Peters' felony hearing involving a number of things. We are going to roll the intro.
Wait a second. That's it.
That's it?
Yeah, that's the melody to Funky Town.
You heard the little towel. That's it. That's a melody to Funky Town. What a day. Can I just say good morning? Hello, Nanya. Hello, Dr. Disinfect. Let us all take a few minutes. Let us sit down. Let us compile and compose ourselves. It was first of all, the hearing yesterday, just so folks understand, among all the other chaos, was only a minute long. It was 60 seconds, Kate Peters' felony hearing. But it was not that hearing that we're going to talk about this morning, although we will watch the 60 to 120 seconds of footage from in the courtroom via towel cam. However, what we're really going to talk about is what happened going into court, what happened a few hours before court, what all of this means. Someone asked me to explain the chart because they didn't understand why Rachel Rollins was connected to Michael Morrissey and how that played into Kate Peter and the PI firm run by Marty Kraft. We'll talk about it. Furthermore, I would just like to say, before anything even started yesterday, and I know a lot of you want to hear what was this like. I was behind the camera. I was not involved in, I was saying questions, but I was not involved in some of these sort of scenes that unfolded. A lot of you probably are wondering, what was that like for Little Towel? You do this a lot. This seems like it was a little bit of a different situation. Maybe we want to hear you talk about it. Well, okay, I can do that. I couldn't do it yesterday afternoon because I had to go to the towel doctor. You know what I'm saying? Priorities. People are always going at me about my priorities. Safety, country, God, family, in that order with academics thrown in there for good measure. I've never said otherwise, so I don't know why people get so up in arms about it. And I also don't know why people work so hard. I think it's a lot of Kate Peters' allies to gaslight me into believing that my work doesn't have value. All right? Just because I do this work independently, it has value. All right, but we'll get to that later in the stream. Furthermore, you can tell a lot about what's going on right now, and I realize there's a lot of active developments. This was a hell of a series of events over the past 24 hours. I'll try to contextualize it all. But the bottom line is, if anyone's attacking Lindsey or Kate or myself right now, those people probably are aligned with Kate Peter. The fact that the chips have fallen this way, I'm just mind blown. Good morning, Nancy. Good morning, Christina. Happy Thanksgiving Eve to all the towel friends. We have a short stream today because I got to do things in the afternoon. You know, I'm trying to do things, physical limitations notwithstanding. And I thought it'd be really fun to spend this morning with you all anyway. I was going to do a stream today in the morning and just spend some time talking with you. I had no idea yesterday was going to play out the way it did. If you missed it, we'll get caught up. I'll take you through it. Listen. I've seen some things. I've been saying this a lot lately, but I just can't quite appropriately contextualize what happened yesterday. I couldn't have if I had tried to stream yesterday. I just would have been yelling. I'm like, oh my God. But now that I've had some time to sleep on it, I don't know about you all, but I went to bed at, 6 or 7 p.m. I had a good night's rest. I don't know. It was not restless, I suppose. So anyway, I wake up this morning and I start thinking to myself, wait a minute, that was a crazy situation yesterday. It is the culmination of so much. I have to talk about it. So we're going to watch it. We're going to do that. Good to see so many of you. And then I'll give you my perspective. All right. So let's set the scene a little bit. All right. So what was yesterday? Tuesday. It was a sleepy Tuesday. It's Thanksgiving week. So everything kind of slows down in the lead up to the big travel day today and tomorrow. But, things are kind of sleepy around Massachusetts, and, the courts are kind of sleepy. And I'm a little towel, and I'm like, oh, maybe I should go down to this Kate Peter hearing, because this was the big hearing to see if a new special prosecutor would be appointed. Now, I had already reported about on Friday that a new special prosecutor was appointed. Now, this is a felony witness intimidation case where Kate Peter on video drove this circumlocuitous route to go in front of the courthouse during like a Karen Reed or TurtleBoy hearing, and there was a woman there named Lauren Murray who has a connection to TurtleBoy, and Kate and TurtleBoy really don't like each other. So Kate started tormenting Lauren Murray. She flipped her off, and she apparently told her to take her life. And what's weird is Kate had Lauren had an order out at the time against Kate. So Kate was charged with a felony and misdemeanors, I think, for witness intimidation against Lauren and a RO violation, which is being heard in Dedham District Court. Now, the Kate Peter case has just had this tormented procedural history where there was like a special prosecutor assigned for a while, and then the special prosecutor dropped off a month or two ago, and the Norfolk District Attorney, Michael Morrissey, who Kate Peter talks to directly, tried to have an ABA twice put in a plea deal for Kate on the case. It's called a green sheet. The judge rejected it both times on the grounds that the judge couldn't understand why there wasn't a special prosecutor on the case. So the judge said on the hearing yesterday, and why people were paying attention to this, it's important that the Norfolk District Attorney's Office come into the next hearing with a decision as to whether there's no conflict and they're going to go forward with this plea deal, or whether there is a conflict and there's now going to be a new special prosecutor. Well, yesterday there was a new special prosecutor, so that's why I wanted to go. Now, I show up, okay, at like, I don't know, 12 o'clock or something. I had to go to the doctor after, so I just had things on my mind. I was just sitting at court because I don't like going to the doctor, especially if I have to get a blood test or something. It scares me. I get nervous. I'm afraid of needles. Anyway, not relevant. The point is, so I'm sitting there and just kind of trying to wait for the court hearing and keep my mind off going to the doctor. Okay, so at like, I don't know what it was, like 12:15, I go into the courthouse, and I, just like normal, I say to the clerks, can I check in for the 2 p.m. hearing as media? And they say, oh, not yet, come back right before lunch ends, and we'll tell you what you need to do. So I go back outside, and there was no one really there. The morning session had run a little long, but there was no one at the courthouse. It was a little abnormal for a Kate Peter hearing. Normally a lot of Lauren Murray's supporters show up, and Lauren shows up, but this was like a procedural hearing, and I'll tell you in a minute why it didn't really matter that no one showed up for the hearing itself, but the folks who didn't show up ended up missing this like wild scene. I wouldn't call it wild, I'd call it cacophonous, or a crescendo of so much online nonsense that's been going on Kate Peter's end, wherein Kate was completely exposed by Lindsey as juxtaposing what Kate says online versus how she responds in person. No one knew. I didn't know that was going to happen. It was chaos, okay? But the point is, so I go there, and as it's getting closer to 2 o'clock, Lindsey pulls up. I'm not like sitting with her. She just pulls up. And I'm like, okay, like what's going to happen here? But I'm really only focused on like standing on the sidewalk and seeing when Kate Peter arrives to court. And oddly, what made it a little eerie was that there was no one there. Normally when, like I said, there's this crowd outside district court. It's smaller than the Karen Reed or TurtleBoy hearings, but it's a crowd. No one was there. So it was, I don't know how to explain it, eerie. But I'm just sitting there in my car, and I get out, and I don't even go over to Lindsey because I'm like, I don't know what she's doing or what she is thinking about. So I go outside my car, and I'm getting ready to film Kate. And I'm like, okay, something is going to happen right now. This was as Kate's arriving to court. We'll watch the video, but I just want to set the scene for you. As Kate's arriving to court, I have some questions about news that had broken earlier in the day. So let's scroll down right here, because that was the culmination of it, some of these exchanges. But let's scroll down to the news that broke early in the morning. Okay, it was this about PI Marty Kraft. And let me just read you my report. This went out yesterday at 8:06 a.m. Okay. Breaking. Private investigator Marty Kraft, who had ties to Kate Peter and others in the orbit of Norfolk DA Michael Morrissey's investigation of Karen Reed and Aiden Turtleboy Kearney, has lost his PI license as of November 12, 2025. Per a document listed online by the state police, Kraft's name, nor that of his firm Kraft Investigations, appears registered with an active license. Peter, online commentator known by the character Masshole Troll Mafia, I said Mafia, Troll Mafia, what are you going to do, was revealed to have access to Kraft's private PI backend software and his Gmail account, via recent leaks revealed by Lindsey Gaetani. Read more here. It has also been reported that Kraft, as early as 2022, had contact with Brian Tully, someone who spoke, that was the state police officer who investigated Karen Reed and Aiden Kearney, someone who also spoke directly to Kate Peter and Jen McCabe in the context of Tully's unit investigating Matthew Farwell's involvement in Sandra Birchmore's death. Tully's unit, via John Fanning, cleared Farwell, but the feds charged Farwell 2 years later and exposed a clear MSP cover-up, in my view. Like how I used the word cleared in two different ways there. I didn't even mean to do that. It is unclear if the loss of Kraft's PI license had to do with Peter and her online Discord friends working for Kraft's firm to, among other things, help Brian Tully leak an unredacted copy of Lindsey's cell phone extraction with only messages from Tully to Lindsey and from Kate to Lindsey removed, along with an audio message from former state trooper Leah Bathtub Genduso, someone who speaks directly to Kate Peter, that was also removed. Recently, I reported Kraft received hundreds of thousands of dollars in state funds starting in 2021 after a multi-year lull prior to that point in time. Although the funding state agencies are unclear at this time. Read more here. Likewise, former DEA agent Sean McDonough also reported the following in July of 2025. Quote, the back channel has confirmed that Marty Kraft, a former Boston cop turned private investigator, is at the center of a growing firestorm after leaving his loaded firearm inside a home occupied by minors. Sources on the North Shore, speaking under the condition of anonymity, say Kraft is now in serious danger of losing his PI license and possibly facing further consequences. The incident has sent shockwaves through both law enforcement and investigative circles. Now, take a look at this. What's the tie in here? Well, there's a number of ties. One, you're going to see evidence that Kate Peter had access to Marty Kraft's back-end PI software. That's out there. You're also going to see that this guy, Marty Kraft, according to this document, which has been out there, and Kyle Sharkey was kind enough to remind me of it, which is a connection I really should have included in my post, and I felt bad for overlooking it, but this is a tough one to remember. This guy, Steven Verano, is the person who's signed up to search Aiden Kearney's, or part of the taint team for Aiden Kearney's phone. He is on the board of directors of something called the Licensed Private Detectives Association of Massachusetts, of which Marty Kraft was the president. I don't know if he's still the president, but he is on this document. So there you go. You see what I'm saying? It is a absolutely fascinating situation, and I think it's very interesting. Now, I think part of why all of this ties together is for a number of reasons, okay? One, I think this whole situation, all right, and we'll go to this thing with Kate in a second. I think all of this ties back to two warring factions, okay? The Norfolk DA on his side with Brian Tully's unit and Kate Peter and Marty Kraft, the PI. On the other side, you had Karen Reed and Aiden Kearney. The way they had ties to the feds, I think, or connections that were helping, and there was a war between the U.S. DOJ under Levy and Rollins, and on the other side, Norfolk DA Michael Morrissey, and it was a proxy war because TurtleBoy and Karen were fighting with the Fed on the side of the feds, and Kate was like the operative fighting for Michael Morrissey. That's my opinion, okay? If you think about it in that context, then everything kind of makes a lot more sense, all right? The way people are moving. But the reason why this brings in Lindsey is, as part starting in the fall of 2023 of Kate and what I believe to be Kraft's firm and others, efforts to get Aiden Kearney to flip on Karen Reed. Not per se to charge Aiden Kearney. That was part of it, but to get him to flip on Karen Reed. So there would be backup charges if she got away, quote, with the charges related to John O'Keefe's death. And therefore, I believe as part and parcel of that strategy, Kate has had long cover moles because she just knows people in the orbit of Turtle Riders who are in Aiden Kearney's orbit. And I think the way this manifests itself is that Aiden Kearney, for all of his different strengths in PR and whatever it may be. What he doesn't see is that if someone just says, hey, I really like and support you, you shouldn't trust them. That's how you get a mole in your orbit. So I think Kate was used to like help this unit and the DA psychologically profile Aiden as a weak link to get to Karen. All right. And I think that's why starting in the fall of 2023, all these people in Aiden's orbit were either moles for Kate or people Kate was trying to make moles. All right. That's why Lindsey Gaetani was an unwitting honeypot. I don't think at any point in time she was witting in Kate's scheme. I think Kate knew if she revealed what she was up to, then Lindsey would never have gone along with it because there was never going to be justice. Pursuing Aiden was only for the purposes of getting him to flip on Karen. That's my opinion. So that's one of the primary reasons why folks have to understand the way this started was that Kate Peter, I think, and Brian Tully and the Norfolk DA looked at Lindsey as an unwitting honeypot who would be tactically useful in the context of a wider psychological profile of Aidan Kearney to tease out his weaknesses and therefore get him to give up information on Karen Reed in exchange for his worst fears, going to jail, going away. Everybody on the same page? Now, we'll talk about later how I think the Norfolk DA needed a scapegoat to make it all go away, and that was always the plan, to kind of blame it on Lindsey, or like whatever the hell. Because Leah Genduso shouldn't have been telling Lindsey to have direct contact with Ken Mello, who was the special prosecutor at the time on the Kearney case. Leah Genduso is a former state trooper who went from a dispatcher to a trooper, spent 6 years as a dispatcher, 4 years as a trooper. There's no way she didn't learn that you can't have ex parte contact with a prosecutor if you're a witness. So I just think it was all a setup. I think it was designed to compromise Aiden's cases so they'd have a backdoor to dismiss them and have a little cover. And I think that's the issue here. All right. It was procedural due process violations out the wazoo. It was Lindsey becoming an unwitting honeypot. And then to really set the background for the exchange between Kate and Lindsey yesterday, we have to look at April 2024. All right. Because the timeline here is very important. All right, Aiden goes to jail on a bail revocation December 26, 2023. He gets released February 23rd, 2024. That causes its own tension with Karen. Okay, that's what I think the point was. It was an operation to separate Aiden and Karen. Lindsey was not part of it. Kate and her people and Tully were doing this. It was very tactical. All right. But Lindsey still had value. Okay, but I think Kate correctly knew that Lindsey would, when she figured out what all this was gonna expose it. All right, but so Kate started moving on March 10th at least of 2024. Father Mark Murphy, a defrocked Catholic priest in the Boston area with political ties to Athena Garrison, a perennial Boston City Council candidate. Go do your research on her; it's wild. Anyway, Murphy sets up the Jennings report on March 10th, 2024, and this website is clearly targeting Lindsey Gaetani and myself. Now, it looks like it's doing it for the purposes of supporting TurtleBoy, but I don't think that's what it was really doing. I think it was manifold or twofold, bifold, whatever you want to call it. It had two purposes. One, to get Mark Murphy under the pseudonym Mark Jennings credibility with Aidan Kearney, all right, to become a mole for Kate. Two, it was setting up the ground for Kate with plausible deniability to start smearing Lindsey and I because we were wild cards she correctly judged she couldn't control. All right, that's how I knew this was very tactical. Now, let's take a look in particular at what happens between March 10th of 2024 and April 24th of 2024, which is the start of the first Karen Reed trial. All right, I'm going to play this video from Lindsey that will tell the story. It does a really good job. But let's think about the timing. Yes, Lindsey's tweet this morning was absolutely epic. We'll get to that in a second. But in order to get to yesterday's court hearing, we have to understand what happened with Lindsey's phone extraction. Now, I'm going to let her tell the story via this video. It has 100,000 views. She knows what she's talking about, and it's a good video. And I think folks will understand now what happened here. Brian Tully, when he got that phone extraction from Lindsey, he immediately, in my opinion, was like, oh, you know what? That's really convenient. What if I accidentally leaked this? I'll just, sanitize it. By the way, for folks who don't know in the Intel community, sanitization is when you, even though you know a record's going to be made public, like required by law, you remove certain things that are unseemly, to put it lightly. So Tully sanitized the phone. And what's so interesting about it is it was right when the first Karen Reed trial started. Now, who else did Tully and Kate both talk to? None other than Jen McCabe. Why is that relevant? Well, because who benefited the most from Brian Tully doing this? You want to know? I have a chart, folks. I have a chat. You want to see the chat? It's not a chart. It's actually a comparison of two graphs. All right, we're going to look at a comparison of two graphs. Hello, Jim. Oh, Troy, you got to look at it. We'll bring it up on screen with a content warning. Let's just say Kate Peter was exposed as a serious hypocrite by Lindsey this morning. You can go to Lindsey Gaetani's Twitter, at Lindsey Gaetani. Make sure to give her a follow. But you really want to let Lindsey's post speak for itself. You know what I'm saying? Like, it says volumes, my dear friends. Now, if you're wondering what I'm doing right now, oh, that's right. We should talk about how Kate sabotaged Lindsey's fundraiser as well, because that sets a little context. But first and foremost, let's narrow in on this comparison graph. Where is it now? I know I have it saved. It's this very handy dandy. When you see it, you're going to be like, wow, Grant, that is a handy dandy little chat. Well, it's because I'm a fan of charts. And the specific chart that I am bringing up for you has to do with the Google Analytic results of Jen McCabe's name versus Lindsey Gaetani's name over a specified period of time. Nope, that's not it. That's Marty Crafts. Hold on. I'm getting there. And then the other thing is it ties in, too, because the image that I want has Julie Carpenter going at Lindsey right now, or a few weeks ago, and you can tell exactly who is really interested more so in Kate Peters' agenda than anything else based on who is attacking Lindsey and I right now. Because it's not the Turtle Riders, it's not the Karen Reed folks, it's Kate Peters people that are going most viciously at Lindsey and I, and that tells you a lot, folks. It tells you a lot about who those folks think are able to put this all together. And I also think there's a strategy to divide Aidan Kearney and Karen Reed, divide and conquer, and that's dangerous. I found it! Look at the chat. Where's the chat? I added the chat. Come on now. There it is. Look at this chat. All right, hold on 1 second. I'm bringing up the chart. Okay, so this chat, it is a chat. Now, the reason why I say it's a chat is that it compares the analytics of Jen McCabe's name in Google Trends with Lindsey Gaetani's. All right. Now, if we really zoom in, hold on, I can do this. See, Julie Carpenter's not that relevant. Apparently her nickname is like Peg Bundy or something. I don't really understand what that means. Maybe she's like a modern Al Bundy or something. I don't know, bro. All right, anyway, so take a look at this. As you can see on the left, that is Lindsey Gaetani's name. Now, the period in time we are looking at here is specifically August of 2023. Now, August of 2023. Look at Lindsey and Jen McCabe search results. Jen McCabe, by the way, just so folks understand, it's not that I'm unsympathetic. I defended her on the Google search, whatever. I just think they overreacted a little bit to what they were going through. I understand it wasn't pleasant, but look at Jen's starting in August of 2023. It's not exactly like she was a huge target, okay? I don't mean to downplay this, but over on the right there, that's Jen McCabe's name. Look at the very beginning of her graph. It never goes above like 4 on the Google Trends rating, all right? When she's at, like, taking the, quote, heat from TurtleBoy. Just wasn't really permeating, okay? Now, look at when Lindsey Gaetani shows up for the first time. That one's not circled, all right, on the left chat. That is a huge spike to 100 in December of 2023 when Lindsey and TurtleBoy's situation first spirals out into the courts. Okay, so first of all, let's be clear. You cannot compare anything that Jen McCabe, in my opinion, went through based on this data. Hi, Troll in the North. Grant motion out to move civil case to federal court. Thank you, Christina. Do you have a link? There's a motion out to remove the civil case to federal court. We'll do that in a little bit. Folks, take a look at this. In that chart, okay, you can see right there when Jen McCabe first starts actually getting attention, more than an initial bump. It is specifically in April of 2024. All right, now what happens right at that exact same time, folks? That's when Tully releases Lindsey's unredacted phone extraction with only messages from Tully to Lindsey and from Kate to Lindsey removed. Look at that. Is that really a coincidence? Do you think maybe Jen McCabe's numbers would have been higher if not for everything that was going on with Lindsey? It's a zero-sum equation. Christina, if you have a link to the actual filing, like a PDF, that would be great. If it's just posted as screenshots, less helpful, but I can also check the docket in a second, too. All right, okay, so take a look. Folks, the second thing that happened is Jen McCabe did get a lot of attention during the second Karen Reed and John O'Keefe trial, but that Lindsey also got a bump in attention right then as well. And I think a lot of this traced back to Kate Peter because Lindsey was a useful distraction. Yeah, it was to Karen Reed, to TurtleBoy's benefit. It was whatever, but really it was designed to take the heat off Jen McCabe, in my opinion. All right, so let's listen to Lindsey's overview of this, okay? Because this, I think, explains a little bit of the context of why there was so much animosity. Oh, that was the Marty Kraft one. Hold on, I want the phone extraction leak. Hold on. Oh, actually, I know a way to get to the phone extraction link. It's the top video on her X. And you should follow Lindsey on X. Look, she almost has 4,000 followers. She's a little towel. All right, I'm going to play this video for you.
I just remembered
7 minutes. It's a great explanation of what happened, and it sets the stage for the interaction we're going to watch after this.
Dropping to the ground in shock and horror. Those are the words of Lindsey Gaetani. Imagine this. You agree to help the justice system, and you're told again and again that your privacy will be protected. Then you watch in real time as your entire private life is broadcast online. It is an absolute nightmare. And for this one witness, it became a reality.
So that's the central question here, isn't it? How could a failure this catastrophic even happen? How does a witness's entire life get handed over to the very man she was testifying against? We're going to break down the timeline, step by step, and look at the accounts of everyone involved. All right, let's start at the beginning. This whole story didn't begin with a threat or a demand. It actually began with a promise made to Lindsey Gaetani by the same people who were asking for her help. At first, it was all about choice. The special prosecutor, Ken Mello, he reached out to Lindsey and assured her that her cooperation was completely voluntary. You know, the pitch was simple. Just have a conversation with investigators, and if you don't feel comfortable, you can walk away. No strings attached. Well, that promise of choice, it evaporated pretty quickly. What started as a simple request for some specific text messages suddenly became a demand for her entire phone. And when Lindsey decided against it, remembering she was told she could back out, she was hit with a subpoena. Just like that, the voluntary witness was now a legally compelled one. So with that subpoena in hand, the next step was getting the data off her phone. And this is where a whole new set of promises were made, really specific technical assurances that were all designed to protect her privacy. Picture it. She's in the district attorney's office. In the room are Lindsey, her victim advocate, prosecutor Mello, and Detective Tully. They sit her down and explain exactly how they're going to safeguard all the incredibly sensitive information on her phone. And the main safeguard they offered her was this thing called a reverse taint team. They explained it as this independent group that acts like a filter. They would meticulously go through everything, separate the relevant evidence from her private life, and make sure nothing personal would ever be seen by the prosecution or the defense. On top of that, they added another layer of protection. They assured her that before any data was turned over, a judge would personally have to review and approve it in a formal court hearing. So, between the taint team and a judge, the process sounded absolutely ironclad. And let's be clear, the stakes could not have been higher. We are talking about 15 years of a person's life stored on a single device. Social security numbers, bank records, her children's birth certificates, private photos, privileged communications with her lawyers and her priest. It was, essentially, the digital blueprint of her entire existence. With all those assurances in place, her phone over. Months went by, and then the absolute unthinkable happened. Every single promise that was made to her was broken in the most public and humiliating way imaginable. She found out that the defendant in the case, Aidan Carney, was live on his YouTube show, reading her private information out loud to the world. He had everything. Her entire, unredacted private life had become public entertainment. The scale of this leak is just staggering.
It was approximately 7,000 pages of her most private, unredacted, personal data. Every promised safeguard, the filter, the taint team, the judge's review had all been completely ignored.
In a panic, Prosecutor Mello fired off an email citing a clawback provision, which is a legal way to take back documents sent by mistake, and demanded the data be destroyed. The response from the defense attorney was blunt. "It's your own fault that you sent it." They refused, and the defendant then spread it even more widely.
The institutional response felt just as dismissive. A new special prosecutor, Attorney Cosgrove, was put on the case, and his assessment of what happened to Lindsey? You can't put the toothpaste back in the tube. The damage was done, and it felt like the system was just shrugging its shoulders.
So how did this happen? Well, this is where the official story starts to get really murky. Officials began giving completely conflicting accounts about whether this whole thing was an accident or if it was an intentional choice. At first, the leak was framed as a terrible accident or an error, but in a recorded court hearing, Special Prosecutor Mello admitted the exact opposite. He stated, quote, "It was our decision to give him everything we had," saying they didn't want to be accused of withholding anything. So, not an accident, a choice. And the conflicting stories just kept coming. Detective Tully, the same man who promised her data would be protected, allegedly told her in a phone call after the leak, "Lindsey, I told you, Aiden was going to get everything from your phone." A complete reversal of his initial assurances.
And as if a 7,000-page leak of unredacted data wasn't bad enough, a new, even more serious allegation emerged. The data hadn't just been released, it may have actually been altered first.
Suddenly, the defendant himself started claiming that key pieces of communication were suspiciously missing from the data he received, and this raised the explosive question of evidence tampering. So what was supposedly missing? Well, according to the claims, all the text messages between Lindsey and Detective Tully himself had vanished, gone. And while Lindsey's texts to another person, Kate Peter, were still there, all of Kate Peter's responses back to her after mid-December were also gone. It really suggests someone may have manually removed specific communications before handing everything else over. The fallout from this leak was, as you can imagine, significant. As professional consequences started to surface, the witness, Lindsey, was forced to take on a brand new role she never asked for, fighting for her own accountability. In the aftermath, Special Prosecutor Ken Mello was removed from the case. So was his replacement, Attorney Cosgrove. And Detective Lieutenant Brian Tully, the officer who made those initial promises, he was demoted. The very system she had tried to help had failed her at every single turn. In her own words, "I realized that I was going to have to advocate for myself and my kids by myself through the courts directly, that no one was going to help me." And that leaves us with this final critical question. This whole story highlights a profound vulnerability for witnesses in our digital age. When the legal safeguards that are supposed to protect people just crumble into dust, it raises a fundamental challenge to the very idea of justice itself.
Nancy, I understand. Oh, Nancy, listen, I understand. People have passionate feelings about these different sides, and that's why I worry it becomes a little bit of a team sport, you know, and I don't think people understand if you can't conceptualize Kate Peter having done something bad, you know, come on, you're in a cult. Everyone's capable of fault. And FBI, DOJ, you're a critical thinker. You're someone who thinks a lot about these issues. And if you can't see what Kate Peter did with through trying to control one of Lindsey's first fundraisers, and then when that raised $8,000, Kate made all these weird excuses about the money, and the money had to be paid for the lawyer. Mind you, a lawyer who also worked with Annie Dukem, okay, and was connected to Kate's people, George Papachristos. Kate, instead of like just withdrawing the money and paying it to the lawyer, was like, oh, it won't get withdrawn. So some other lawyer Kate knows, some prosecutor from the Midwest, had to lend Kate another $8,000. So instead of raising the $8,000, Kate raised $16,000. Only gave $8,000 to Lindsey, who then used it to pay her lawyer in full. Got a small amount back, then used that to pay another lawyer. All for, by the way, the Rule 17 process that Lindsey had to go through because of her willingness to be involved in the investigation of Aiden, and even though she didn't realize how they were using her as a honeypot. All right, so don't tell me that. Lindsey deserves to be able to raise money for her defense or for any purpose related to these proceedings, and anyone who tells her otherwise is too engrossed in Kate's propaganda. Now, furthermore, so Kate raised $16,000. We have no idea. There's no receipts, no proof that Kate ever paid back the guy who lent her the $8,000. So you want to talk about someone's name being used? What about the streams where Kate Peter talked about raising donations for Lindsey and she got super chats for her? I can tell you, every single donation that I raised for Lindsey, including my pledge to double what we raised during a certain period of time, went to the third-party payee, went to Lindsey's fund. That's what we did, because I lived up to it. Did Kate? No. No proof she ever sent any of those stream donations to Lindsey. You see Lindsey out there complaining about that? No, because she's not doing it for money. She's doing it for justice. Furthermore, Elisa also did streams for Lindsey where donations came in. Did she ever send any of that to her? Is there any proof of those funds ever being donated or ever being sent? No. All right, these people hid in plain sight because they were willing to say that Karen Reed was responsible for John's death. You can't just say because they believe that you're just going to never, ever address anything they've done wrong. No. No. It's 100% right. Everything that I've said, I don't know if you're talking to FBI, DOJ, or myself, but my point is everything I've said, I believe to be correct. Okay? I know what I'm talking about. I know the order of events. I know who was talking to who. I know how this played out. And I know the price that people paid for realizing what was going on. And we've said before that procedural due process violations have nothing to do with someone's substantive guilt or innocence. Okay? Now, if you're and FBI you know the rules here. You have to be civil. I don't care if you support Karen Reed, don't like Karen Reed, support Kate, don't like Kate, or whatever. I really, especially someone who's a longtime person in the chat, civility is foundational here. So you are welcome to have any opinion you want, but you got to be respectful, especially towards Nancy. You want to take your whatever out on me, I'll deal with it for a little bit, but not Nancy. Nancy's a wonderful talent. I don't want to see it. All right. If Troy can do it, if Jay can do it, FBI, DOJ, you can do it. All right. Don't want to hear any more of that nonsense. Now let's take. We got to read the new filing, by the way, that just came in the Karen Reed case. Thank you to Christina for alerting us to that. That just went up. The Canton aristocracy is moving to remove the Karen Reed's major civil lawsuit to federal court. So I got that filing right here. I got the Google PDF, ladies and gentlemen. I'm going to open that up for us any second now. The thing I want to do first, though, is I want to watch the videos from yesterday. Okay, it was crazy. It was wild. You're going to see Lindsey absolutely own Kate. And listen, is there anything better than seeing Lindsey Gaetani own Kate Peter? After what I just showed you, after what Lindsey went through at the hands of people she thought she could trust. You want to see how it all played out? Let's do it. First of all, I just want to show you, I don't mean to exaggerate, but a lot of you are interested in, I think, what lies beneath with the whole Kate Peter component of this story. Because let me just say, I just was at the courthouse, okay? Like, I go to the court, like, even the judge, before she ruled on the motion to let me film it, was like, oh, this gentleman has been here before, covered this case. Give me a little nod. I was like, yes, Judge. I didn't say anything. I was like, yes, Judge. Anyway, a lot of you are interested in this. All right, first of all, when Kate arrived, all right, just me talking to her, Kate didn't even know Lindsey was there. That's what makes this so fascinating. When you're going to watch the hearing, then this first video where Kate tries to walk up to me. I didn't want to accept the card she tried to hand me. I literally was like, does this have ricin in it? She's trying to poison me. Oh, my God. Like, she's very brazen. I was like, I'm not touching that. I don't have a biohazard suit on, bro. Like, I am not touching that shit. I didn't know if it was like a bribe, if she had like drawn like Lindsey as a French woman on the Titanic naked or something. I was like, listen, I'm not touching that shit with a 10-foot pole. I don't trust that woman. So anyway, she tries to give me this card and I don't take it. And Kate did not know Lindsey was there. So Kate walks around the corner in the beginning of that video and looks to the right. She sees Lindsey. We're going to then see Lindsey tries to get the card from her, and Kate just won't give it to her later. And Lindsey just owns her. But the point is, 70,000 of you watched that, and then 85,000 of you watched Kate and Lindsey's interaction. I'm just baffled. I'm baffled by it all. It's like that Mohegan Sun commercial. Oh, the wonder of it all. But seriously, I'm baffled. I don't understand. I get that this is important because of what happened to Lindsey and how the system took advantage of the vulnerable and even went a little overboard on how they were like personalizing prosecutions. Okay, I get that. But are you kidding me? Like, what is half the freaking 128 area interested in all this? It blows my mind. I'm glad you're listening, but I don't understand it. All right. So when I say like people were blown away by this yesterday, I didn't even realize the scope of it. I was reading some of the comments, but my word, just blown away. All right, now, no, all right, I have to correct this misinformation. Proctor's phone was not disclosed publicly, okay? Michael Proctor filed in a document with the Brian Walsh judge and the Miles King judge and otherwise, from his lawyer, a statement saying that he did not have 12 years of records of his phone. Sometime in July of 2025, that all changed and 12 years of those records came out, which caused his lawyer to make a material misrepresentation and withdraw, and caused Proctor to withdraw his appeal, and the state police union to withdraw their support of his appeal. So tell me, no, it absolutely was not disclosed. That was the federal government, in my opinion, cloning that phone to see if Proctor would obstruct justice. They didn't tell him they cloned it. Why else would he just randomly just drop every appeal? Bro, they set him up in a way to catch him. It wasn't leaked like Tully did to Lindsey's phone. The feds cloned the phone, waited for Proctor to make a material misrepresentation, in my opinion, and then moved on him. Clear as day. All right, we're watching this. We're watching it. An FBI DOJ, I don't know if you said you were going to, I don't know if you're going to go along with this decorum thing, but you know the rules. As long as you can be respectful and people feel comfortable, you can stay. But if I see you starting to go down that road again of attacking people because Kate Peter is being criticized, I'm not going to have it. All right? Because it undermines cogent discourse. It's what enables this to happen, and we don't do that. You want this republic to stay strong, then you have to be able to criticize those you like, and you have to be able to praise those you dislike. Okay? Or our system is broken, and we're just in camps, and we'll never get out of it. We're watching this, though, and then we're reading the filing. And no one's going to tell me otherwise. I'm a little towel. You're a towel.
I did hear from him, but you're not expecting him today? Mr. Clerk, have you had any contact with him?
I have not yet. I do have his phone number, so I will give him a call.
Okay.
I was just kind of given this case from a prior prosecutor.
Okay, so why don't we give it another call, and if...
I believe he did contact...
Oh, he contacted
the district attorney's office, perhaps ADA...
He didn't contact the clerk's office, though?
No.
I believe it was a family emergency.
Okay, so he may not even be available to give us
I think
dates.
that's the problem. I'm not sure. They may have given dates to Nelson Francois, assistant district attorney.
He called him. He gave dates to me. Yeah.
I'm sorry, he gave you dates?
Yes.
Oh, great. Sorry, I guess I should have started with you. What dates did he give you?
He's asking either the 26th or 30th of January.
Does it matter to you which day?
No, I have no preference on those dates.
Okay. Mr. Clark, is one better for us?
They're both the same. So whatever.
All right, so let's do the 26th of January then.
I'm not sure if 2 o'clock is requested by anyone.
Did he tell you whether he wanted at 2 o'clock?
I think he tends to do the afternoon just because some of the...
And does that work better?
That does work, yeah.
Okay, so we'll put it on for 2 p.m. then on January 26th.
Matter is continued until January 26th at 2 p.m. for CME.
Kate Peter, did any comment on Marty Kraft losing his license as a PI? Did you use his firm's resources to release Lindsey Gaetani's phone extraction, Kate Peter?
Why are you running from
Furthermore, Kate Peter, is it true that you were the person who used Deanna Corby and Meredith O'Neill to release derogatory information about Lindsey Gaetani. Kate Peter, it's really unfortunate that you won't answer these questions. You speak to her directly, and it's obvious, and if you deny it, we have people who can confirm it. One of them is standing 20 feet from you. Yes, it's not worth it. You should walk inside because your very existence is an insult to my intelligence and the integrity of our judicial system. I'm offended by your presence in front of me. I don't believe that you're authentic, and I refuse to engage with you on that basis. You are not a towel. You are the antithesis of a towel, in fact, and I don't even have questions for you because I wouldn't be willing to listen to your answers. God bless America.
Hey, you wanted to give something to Grant? I'll take it. What did you want to give to him? You don't want to give out something you wanted to give to Grant? You don't want to give it? I'll take it from you, Kate.
You have so much to say online. Oh, Kate Peter's afraid of Lindsey. Bye, Kate. Bye, Kate.
Give me the envelope, Kate. What's in it, Kate? What's in the envelope, Kate?
Kate Peter, you cost
me. Such a coward. You are such a coward. From afar, Shrek. Why are you talk to Grant? Why are you sending me messages over and over again that I didn't give you? Why are you defending her? You don't know her.
Okay, I'm trying to find out.
You don't know her. How do you think you know her?
Okay. And then tell me. I'll be listening.
I've been trying to tell you. You're not willing to listen. I've been trying to tell you, buddy.
Okay, I'm listening. Come on, don't do this.
Now, I mean, I know
okay,
you're
okay, okay, cool. Listen, I'm not against you ever. You know,
I don't know. I don't know. I mean, you're defending. How can you defend her?
I'm not defending her. I'm not. You know what I'm saying? I don't want to do this in front of her.
You want to do it in chat when she's not there? You get that was a reference to him coming in this chat the other day, right? That was 100% a reference to him coming in this chat. You know what I'm saying? Nunkin's like, I've sunk your battleship, may Poseidon have mercy on your soul. All right, let's read this new filing. Let me get the thing up and running here. Everybody ready to read it? That was a day. Let me just tell you, that was a day. We'll talk more about it after we get through this filing, which is 66 pages. And then if the Cosgrove filing from the TurtleBoy case goes up as well, we'll go ahead and read that. But for now, we're going to go through this. Everybody ready? Everybody erudite, cogent, informed little towels. Who's ready to learn? We're going to learn. It's court document reading time. I'm not a lawyer. This is not legal advice. I'm a little towel. I'm going to sit there. We're all going to learn. We're going to listen. I have no idea what this is going to be about. All right. We thought yesterday was a big deal. You saw, I mean, the clips speak for themselves. Kate wouldn't even look Lindsey in the eye. This woman who talks, Kate, who talks so much nonsense online. When she actually has to talk to someone who's far more intelligent than her and has to address her after what she did to Lindsey, has to look her in the eye, she can't even do it. You know why? Because she's got a guilty conscience, in my opinion. Wears on the souls of the nefarious. And may God bring that to them as their punishment. Maybe in this lifetime, ladies and gentlemen, they will not come to realize the temporal consequences of their sin. But let those people, non-temporally though it may be, experience it by virtue of moments like that, where they are forced to betray their own inner latent guilt in the form of not being able to look the person they did wrong in the eye. Oh, it is what we would call catharsis manifest. Someone spoke once about democracy manifest. A great man. Democracy manifest. I demand my chicken wings. Very famous meme. The point is, I don't know what I was going to compare that to. Something about Kate Peter getting put in the back of a police car, screaming, "This is democracy manifest," made me laugh. Good morning, Bunny. Oh my goodness. Pete Bunny, it's Bunny Towel. Pete Bunny Towel's here to see you, Bunny Towel. He is so excited. He's happy to see you. Did you all know this is Pete Bunny Towel? He's our companion. He just sits in the chair over there, yells about commies, and then sometimes when Bunny Towel shows up, he's like, hey, oh my goodness, it's Bunny Towel, and we get to read a motion? Oh, I'm an excited Peep Bunny Towel. All right, so let's see whatever the hell this is. We're going to have it read to us by the helpful AI, and as soon as it starts reading, bunnies always kick their feet? He says guilty as charged. That's the only way he can move, Nunya. He has to move. He says are you telling him to just sit still? You want him to go on some kind of moving apparatus? He can't move. Look at Bunny. Peep Bunny. Peep says peep with like 42 hearts. Oh, he's looking over at the comment. He is an excitable Peep Bunny Towel. He's going to jump out of the chair. But he is so excited to see Bunny Towel. Oh, what a day. All right, so for those of you just tuning in, time to read the new motion just up on the Karen Reed civil case docket that she filed against Michael Proctor, Yuri Buchanan, Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, and Brian Higgins out of Bristol Superior Co-op, which is going to get consolidated with the O'Keefe family's lawsuit against Karen and C.F. McCarthy's of the Waterfall over in Plymouth. So, here we go. People are being stuffed. Oh, no, people being stuffed in cop cars. I see. Well, how many of them yelled, "This is Democracy Manifest"? All right, Pete, should we start reading this document? All right, here we go. Let's do it. Buckle up. We went from Kate, Peter, and Lindsay's epic showdown, which we will talk about more later, to reading this document. It has to scan all 66 pages, apparently. It must have some like OCR like script built into the reader I use. So look at it doing its thing. Look at it, little towels. Being an efficient, erudite little machine. Oh, what do you mean you didn't find any text? Stop putting your things this way. All right, that's it. That's it. That's it. That's it. Make your briefs and documents OCR readable. How dare you? This is a travesty. This is a sham. This is a mockery. This is a Travis sham mockery. You understand? Make your briefs PDF readable. Make them OCR scannable. What is wrong with all of you lawyers? If I can't get the damn thing to read in a text-to-speech reader, that means someone who is disabled cannot do it either. Make your documents accessible. You're making Little Towel very upset. Seriously, why is it that big of an ask? If you are going to upload a court document into PDF format, that's absolutely fine. But at the very least, can you please, when it goes on to mass courts, make sure you check the accessibility setting so that the document can be read by text-to-speech readers. It is not helpful in the least, in any sense of the term, Little Towels, if we simply have a situation where disabled people, especially people who may not be able to see, cannot read court documents. You lawyers, you've got to put your document into accessibility mode so it can be read by text-to-speech readers. Not just for my purposes. I just have one specific purpose because I wanted to read it out loud. I'm not really the person I'm worried about. It's the people who are visually impaired, who deserve to be able to listen to your documents. You really think a visually impaired person is going to be able to save the PDF, open it into a conversion program, make sure that it's OCR readable, extract the text? No. They're going to put it in their program, they're going to click read, it's going to do its thing, and if it can't do it with the algorithm it has, it's not going to work. So don't do that. I don't know. I got to write some kind of like statute with the lawmakers. I got to say to them, listen, we have to mandate that everything that goes through ECF or everything scanned onto mass courts has to be readable by default by a text-to-speech program. All right? I'm not having any more of this. I refuse to continue running into this problem, not because I really care about it. I can just get around it by doing this very quick conversion. But I don't like the other people who might not be able to do that, who actually rely on being able to have text-to-speech programs, tell them what the documents say, not being able to do it easily. All right? So think about accessibility, you damn lawyers. I ran into this problem the other day as well. I think from these same people in one of their filings. I don't know if it's like a bunch of lawyers who do it this way or if it's how the document gets uploaded. Just check the damn box on your PDF so that it is able to be read and processed by text-to-speech readers. It's not that hard. It infuriates me. You can tell I'm a little bit of a disabled rights advocate, huh? All right, Little Towels, what are we doing? No, that's right. All right, it's 66 pages. So now that's the other frustrating thing. When you do it that way, it's 66 pages. So you know what I have to do? I have to download the text file, which it has done. I have to open the text file. I have to bring this up on the screen for you all so we can actually read it together. Then I have to get the text file to read out loud. All right, it's this convoluted process that's completely inaccessible unless you have vision. If you have vision, that is not why you need a text-to-speech reader unless you are doing something very specific like having a long document read out on screen. All right, let's do it. It worked. Still, I'm displeased.
Date filed 11/25/2025 6:31 p.m. Superior Court, Bristol. Docket number 2507. Please take note. Defendants. Defendants. NEE. ENESE. C. A. NTNESE. SE NE. Street NEIT. ENENE. A. SE. Notice of filing. Notice of removal of action to federal court. Please take notice that Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe and Brian Higgins have, on this date, filed a notice of removal in the United States District Court for the District of Massachusetts pursuant to 28 U.S.C. 1446, it said. A copy of the notice of removal and all accompanying documents is attached hereto as Exhibit 70148588V1. Date filed 11/25/2025 6:31 p.m. Superior Court, Bristol. Docket number 2573 CV00914. Aaron Davis Rosenberg, Esquire. Date filed. The JS44 civil cover sheet and the information, C, Atomaze, firm name, address, and telephone number, Atomaze, if known. Damon M. Seligson, Sheehan Finney Base and Green Counsel for McCabe. Defendants. Defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe and Brian Higgins, collectively, removing defendants, hereby remove case number 2573 CV00914. Entitled Karen Reed, Plaintiff v. Michael Proctor, et al., defendants, from Bristol County Superior Court, the Superior Court, to the United States District Court for the District of Massachusetts pursuant to 28 U.S.C. 1331 and 1441, and as grounds for their removal state as follows. 1. TN filing this notice of removal, removing defendants preserve all defenses and objections, including those pursuant to Federal Rule of Civil Procedure 12, b. C. Charles A. Wright and Arthur R. Miller, Federal Practice and Procedure 1395, 3 DED 2004, quoting Greenberg v. Giannini, 140 F.2D 550, 553, 2D Sir 1944, when a defendant removes an action from a state court in which he has been sucked, he consents to nothing and waives nothing, he is exercising a privilege unconditionally conferred by statute, and, since the district court to which HC must remove it is fixed by law, he has no choice, without which there can be no waiver. 1. Date filed 11/25/2025 6:31 p.m. Row EEO Case 1:25 CV 13588 Document 1 filed 11/25/25 page 2 of 7. Statement of the case. 1. On or about the 17th of November 2025, Plaintiff Karen Reed, plaintiff, filed the above captioned action in the Superior Court, the state court action. The complaint purports to assert 7 causes of action, 42 U.S.C. 1983, malicious prosecution under the Fourth Amendment. Count 1, 42 U.S.C. 1983, supervisor liability. Count 2, 42 U.S.C. 1983, conspiracy to deprive Miss Reed of her Fourth Amendment rights. Count 3, Massachusetts Civil Rights Act. Count 4, common law malicious prosecution. Count 5, intentional infliction of emotional distress. Count 6, and civil conspiracy. Count 7, with counts 3, 4, 5, 6 and 7 being asserted against the removing defendants. A true and correct copy of the complaint, civil action cover. Sheet, Civil Tracking Order, Acceptance of Service on Defendant Brian Tully, and Acceptance of Service on Defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe and Brian Higgins are attached hereto as exhibitor. 2. By way of background, the Superior Court action arises from plaintiff's ongoing and malicious attempt to evade responsibility for the death of John O'Keefe by smearing and defaming witnesses who participated in the prosecution of her. The case is a vengeful abuse of the judicial process, and removing defendants will make arguments in that regard at the appropriate time. Removal. 3. Counsel for removing defendants accepted service of process on removing defendants Pschulf on the 25th of November 2025. CX. pp. 53 to 54. Therefore, removing defendants are timely filing this notice of removal within the 30-day time period from date of *. No proceedings have occurred or been scheduled in the state court action. Accordingly, exhibitor constitutes all process, pleadings, and orders that have been served on removing defendants or retrieved from the Superior Court's docket prior to the filing of this notic. Date filed 11/25/2025 6:31 p.m. Row EEOB Cassette 1:25 CV 13588 Document 1 filed 11/25/25 page 3 of 7. Service set forth in 28 U.S.C. 1446, B.7 C. Murphy Brothers, Inc. v. Mishti Pipe Stringing, Inc. 526 U.S. 344, 354, 1999, 30-day removal period runs from service of summons and complaint. For all named defendants who have been served consent to and join in this removal in accordance with 28 U.S.C. 1446, B.2, a. Defendant Brian Tully's acceptance of service was docketed in the Superior Court on the 24th of November 2025, and counsel for Defendant Tully has confirmed that he assents to this removal. While no acceptance of service has yet been filed with respect to Defendant Set. Yuri Buchenik, Sergeant Buchenik's counsel has informed undersigned counsel that he consents to removal. Upon information and belief, Defendant Michael Proctor has not yet been served, but his counsel has advised undersigned counsel that Defendant Proctor consents to removal as well. A civil action removed pursuant to Section 1441, requires the consent of all defendants who have been served. See 28 U.S.C. 1446, B.2, 1441, C.2, C. Also Hill v. Boston, 706 F. Sup. 966, 968, D. Mass 1989. 5. Venue is proper in this court pursuant to 28 U.S.C. 1441, A, and 1446, A, because the United States District Court for the District of Massachusetts is the federal district in which the Superior Court is located and where the state court action was originally filed. 6. As required by 28 U.S.C. 1446, D, removing defendants will promptly serve written notice of the filing of this notice of removal and the removal of the state court action on counsel for plaintiff, as evidenced by the attached certificate of service, and will promptly file the same with the clerk of the Superior Court. 7. Pursuant to 28 U.S.C. 1446, A, and L.R., D. Mass. 81.1, within 28 days of the filing of this notice of removal, removing defendants shall file certified copies of all records and removing defendants have not yet filed an answer or have responded to the complaint, but will file such an answer and / or response, abscontention, within 21 days of Skavike in accordance with Fed. R. Civilian. P81, C. 2. As noted, removing defendants accepted service of process on November 25, 2025. 3. Date filed 11/25/2025 6:31 p.m. Re-I4 Case 1:25 CV13588 Document 1 filed 11/25/25 page 4 of 7. Proceedings in the Superior Court, as well as a certified copy of the docket and all docket entries. 8. The removal of this action terminates all potential proceedings in the Superior Court. C 28 U.S.C. 1446, d. Federal jurisdiction exists under 28 U.S.C. 1331. 9. This is a civil action over which this court has original jurisdiction under 28 U.S.C. 1331 and is one that may be removed to this court under 28 U.S.C. 1441, a, because, as set forth more fully below, plaintiff's federal civil rights claim against removing defendants, namely Count 3, 42 U.S.C. 1983, conspiracy to deprive Miss Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins, is exclusively and expressly based upon the federal statute, 42 U.S.C. 1983, f. sec. And, therefore, raises substantial federal issues central to establishing plaintiff's claims for relief. Degree 10. In particular, plaintiff alleges in Count 3 of the complaint that the removing defendants violated her federal civil rights by purportedly acting in concert to deprive her of her Fourth Amendment rights under the United States Constitution. Where a complaint invokes 42 U.S.C. 1983, federal question jurisdiction exists. C. E.G. Local Union Number 12004, United Steelworkers of v. Massachusetts, 377 F.3D 64, 75, 1st Sir 2004, quoting Bell v. Hood, 327. U.S. 678, 682-83, 1946, almost by definition, a claim under 1983 arises under federal law, and will support federal question jurisdiction so long as it does not clearly appear to be immaterial and made solely for the purpose of obtaining jurisdiction. See also Nivs v. Y. 4. Removing defendants have good and sufficient defenses to this action, and do not waive any defenses, jurisdictional or otherwise, by the filing of this notice. Removing defendants intend no admission of fact, law, or liability by this notice, and expressly reserve all defenses and forward/or motions. Counts and 2 of the complaint ask at 42 U.S.C. 1983 claims against defendants Proctor, Buchanan, and Tully. 4. Date filed 11/25/2025 6:31 p.m. Re-01I4 Cassette 1:25 CV13588 Document 1 filed 11/25/25 page 5 of 7. McSweeney, 73 F. Sup. 2D 98, 101, D. Mass 1999, providing court had jurisdiction over counts alleging conspiracy to deprive plaintiffs of their constitutional rights under 42 U.S.C. 1983. 11. In addition, this court has jurisdiction over the remaining counts in the complaint by way of supplemental jurisdiction under 28 U.S.C. 1367, a, which provides, in relevant part, in any civil action of which the district courts have original jurisdiction, the district courts shall have supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy. 12. Indeed, the First Circuit has explained, state and federal claims are part of the same case or controversy for the purposes of Section 1367, a, if they derive from a common nucleus of operative fact or are such that they would ordinarily be expected to be treated in one judicial proceeding. All State Interiors and Exteriors, Inc. v. Stoner Street Const, LLC, 730. F.3D 67, 72, 1st Sir 2013, quoting Penobscot Indian Nation v. Key Bank of Me, 112 F.3D 538. 564, 1st Sir. 1997. Plaintiff's claims refer to and rest upon the same allegations. CX. A. Compel. FF 109, 118, 128, 140, 148, 155, 161, incorporating the allegations as set forth in the preceding paragraphs. 13. Accordingly, this court may exercise supplemental jurisdiction over the remaining 4 state law and common law claims, counts 4 through 7, in the complaint. Conclusion. Wherefore, defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe and Brian Higgins respectfully request that the state court action be removed to the United District Court for the District of Massachusetts and that the court enter such order as may be necessary to accomplish the requested removal. Date filed 11/25/2025 6:31 p.m. Superior Court, Bristol. Docket number 2573 CV 914 copyright symbol case 1:25 CV 12588. Dated, the 25th of November, 2025. Documentary filed 11/25/25 page 6 of 7. Respectfully submitted. Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. By their attorneys. 4. EDFVE. OL and DWF. 2 of OID. James L. Tuxbury, BBO number 624916. Hinckley Allen LLP. 28 State Street. Boston, Ma 02109. 617, 378, 4162. Tuxbury@heinekleverlichen.com. Date filed 11/25/2025 6:31 p.m. Roe case 1:25 CV 13588 document 1 filed 11/25/25 page 7 of 7.
Yes.
Certificate of Service. I hereby certify that the foregoing.
All right. Hello. All right. So we listened to that 7-page motion. Now listen, there's a lot of... federal court doesn't have cameras. It's not recorded. It's, I guess, more beneficial to governmental defendants on the sovereign immunity question. However, there's a big caveat here. It also tips the hand that these defendants, the Canton aristocracy, as I call them, do not want this case litigated in public. So that tells you something. At least public in the sense that it would be recorded and broadcast. But yes, listen, Social Change Warrior was saying sometimes people get kind of inculcated into a cult of personality and then it becomes hard for them to see the forest through the trees. I agree. And I think Kate Peters kind of a master magician, right? Like Elisa, Kevin Linehan. You'd be surprised. I think a lot of these people are Kate people. I think the wider picture is that a lot of them either, like the power brokers, the people who like are doing PR, in the orbit of the Justice for John O'Keefe movement, they either work for Kate, with Kate, or tolerate Kate. Even the people who I think are more interested in helping Jen McCabe or Tully or whatever, and may not necessarily like Kate, some of the O'Keefe family members, whatever. I think even those people are like, all right, well, some of the faction within our side made a choice to work with her, so she can do no wrong. No, that's exactly what allowed Tully's behavior to permeate. All right, we got new filings up on the TurtleBoy docket. We had those incredible scenes yesterday with Lindsey and Kate Peter. As we're waiting for the TurtleBoy filings to go up, we're going to watch a video. All right, that'll get us caught up on everything related to these overlapping concentric social circles of influence, how Adam Deutsch's run all ties in 100%. So what's in, Nunya says, if you had to lie about something and then take a polygraph, I wonder if someone worked real hard to reinforce the lie in someone's mind, maybe it would impact the test. Okay, a few things. One, you can kind of read about J. Edgar Hoover's early analysis of, or listen to him talking to, I think it was LBJ in 60, 64, maybe 65, about polygraph tests. In the context, I forget who they polygraphed. It was someone related to the JFK or Warren Commission. Polygraphs are not used to determine the veracity of your statements. Polygraphs are like a psychological analysis. What they're used to determine is your reaction to questions under pressure. So the baseline assumption of a polygraph is that if you get uncomfortable because someone asked you a question, you're probably lying. Now, first of all, anyone trained in counterintelligence is going to pass a polygraph. Robert Ames, one of the spies for the Soviets in the U.S., passed like 40 polygraphs. It's not a question of that. It's a question of what is the point. The point is to read you. It can't be used in court. It's not evidence of anything. It's probably less reliable than a drug dog. But the point is that it's used to analyze. If you consent to it, like to work for the CIA or whatever, you're basically saying, okay, you can look at what type of questions make me nervous. All right, well, if you're trained in counterintel, no questions are going to make you fucking nervous, bro. You're going to sit there and be like, yeah, it is what it is. You know what I'm saying? Now, in terms of like people who try to train for a polygraph, I don't think you can really do that. I don't think like a layperson, you could pour like coffee on your lap, or you could do something, but it's going to give a reading of like inconclusive, probably. Like if you alter your mental state through drugs or whatever, it's not going to read right. What it's looking for is like against a baseline of human cognition. How are you flowing? How are you ebbing and flowing? So the only way to fake it is to understand what it's doing. And you wouldn't even be faking it. Like, you wouldn't even be convincing yourself of a lie. What you'd be doing is like, it doesn't matter. If your reaction is everything that they're saying to me right now, it doesn't matter, then it's not going to work. It's going to just be like, okay, this person's just answering questions. So it's not a foolproof methodology, Nunya, is my point. And it's something that what you really have to go back to is like the 60s, like when lie detector technology was first developed. It hasn't really evolved since then. It has a unitary purpose, which is a psychological analysis of your body, like your heart rate, your EKG, whatever the hell it's measuring, your vital signs. It does all these measurements because it's just looking for a measurement against a baseline. And it has a baseline for you, and then it has a baseline probably for like what humans are, and it probably has to break them up into psychoanalytic categories to control for natural differences in personality type and all that stuff. But that's what a lie detector is. It's just measuring your in-the-moment response to interrogation against what would otherwise look like, what was the word? Nervousness. It really just wants to know if you're nervous. That's why I think it's such a flawed instrument. If it's an instrument that records phenomena such as blood pressure, pulse rate, and respiratory rate, these psychological responses are involuntary, ideal for detecting changes and indicating deception, says Social Change Warrior. Absolutely. So I'm not saying that there isn't some legitimate medical basis for measuring body vital signs, especially electromagnetic body vital signs or other involuntary reactions, as an indication of deception. That's really like the core of it. That is not wrong. That is valid science. What is invalid and what does not yet work, and which probably will not work until we're at like Minority Report, like in your brain analysis of what you're thinking by an external chip or something. It's scary. That you're never going to be able to actually do that. So what it really is if you know. So think about it like this. If you study Freud and Jung and you know what psychoanalysis is, and you're doing psychoanalysis, that's really good. But if someone wants to do psychoanalysis on you, you have to be a willing participant. If you don't know what psychoanalysis is, you're going to have no idea what is happening when you're going through psychoanalysis treatment because you're not going to understand the discipline. It's very similar here with a lie detector test, but easier in some sense to fool. If you know what it's measuring, if you know that there are involuntary reactions, do you know what BUDS is, Basic Underwater Demolition School? Do you know why they basically drown the Navy SEALs? Do you think it's because they want to drown them? No. Do you think it's fun for the instructors? No. They are overriding your baseline response, your psychosocial, your whatever the hell it's called, limbic system response to drowning. Okay, when you drown and you're not trained for it, you know how you react? You basically panic, causing yourself to try to breathe, thus killing yourself faster. Do you see what I'm saying? You're drowning. You don't know what to do. What do you think your body's going to involuntarily react? How do you think your body's going to involuntarily react to drowning? It's going to look for air by breathing, and then you're going to swallow more water and die. So we drown our Navy SEALs basically so that no matter what happens to them, whether they're trapped underwater, whether they like get caught on something, whether they're in like a tight submersible or whatever situation you put them in, they might go out, but they're not going to panic. They are going to be 100% in the moment. They're going to do everything that they can in the precise order that they're supposed to, and they're going to give themselves and their colleagues and their fellow soldiers the best chance, SEALs, the best chance of survival. And that's exactly why they drown them. It's called work hardening. So, no, you cannot, like if you have a polygraph tomorrow, you're going to go in there, and even if you're just a nervous person, you're just going to be a wreck. You're not going to do well. If you know what a polygraph is, if you have been basically analogous to being drowned over and over and over again, yeah, bro, it's just going to be another day. But for some people, yeah, exactly. You really can condition the brain to do anything, okay? The brain is a muscle, fundamentally. It's driven by synaptic sort of firing. But synaptic firing, what you really have to think about it like is like, we kind of have like spider webs in our brains. They're synapses. And your synapses, like, they're dictated by what you choose to focus on as being important. So, like, if your synapses are like linear, if you're like, okay, I'm going to do the same thing every day, and not only that, I'm going to consume the same thing every day, then your synapses are going to harden very linearly. Like, you're only going to focus on what you're doing. So if you like football, if your life's built around football, like, you're going to only do that. That's synaptic conditioning. I wouldn't call it conditioning because the synapses aren't being conditioned. What's happening is you're like building a neural network. And if your neural network is like layered on very specific things, it's not going to branch. It's just going to be one line, okay? Those are pretty simple humans. When you're really, the next level up from that is when you have a map like of synapses that can trace disparate connections. So it's not just your daily life, but it's like, what information are you picking up? How are those connections spidering out? And most people silo their knowledge. So you pick one field, you get really good at it, and then your synaptic sort of web for that field, a branch of your main sort of epistemology. So your main line, right, of knowledge branches off a little bit. You have one really good area that has a lot of really well-built webs. Okay, there are some people, a lot of them on the spectrum. I don't know a lot about this. I'm not a doctor. I'm just telling you a basic understanding of why this conditioning can happen and how it works. There are some people with synaptic maps, especially on the autistic spectrum, that are just all encompassing. So like, it's not just you have your main strand, but every single branch that you have is like a refined, well-hardened neural network. So those people living in that world, you're already forced to master it, because imagine how overwhelming it would be if just every minute of every day, like every minute, your brain were going from one moment like the Catholic Protestant Reformation to the next minute like the Westphalian Peace to James Joyce to like Hunter S. Thompson to Ida Tarbell to the fall of Rome and lectures about Constantinople and like the Younger Dryas period. Just imagine never being able to turn it off. So every moment of the day, your brain is just thinking about all of this stuff, and it's right, because you have to put the time in. If you don't train it, you will just be thinking about absurd, stupid shit all day, constantly. You'll never focus on anything important. But if you train it, if those synaptic pathways are trained to know philosophy and math and physics and history and literature and law and all these different things, okay, well, use it or lose it. That's how it really works. And then you've really like taken all three of the basic steps, and then if you want to apply it to like a lie detector test, or by analogy, the next step up is, and what the Stoics I think tried to do, was you master those different neural networks and understand the form of your own understanding. And by virtue of that, there's never a time, hopefully, unless something misfires, where you will lose control. It's all about control of self. That's why I don't believe in like God being internal. Nonsense. It's external. I don't believe us 3D beings in a world we can't even fully perceive or understand on this biosphere of a rock floating through space are the be-all, end-all. But I do think there is something to be said about mastery of cognition over emotion. If you do that, you've basically transcended, because 99% of people are just being driven by their daily needs or their emotions. So the second you're no longer subject to those machinations, it's first a matter of learning the subject so that you have discipline in your neural networks. And then it's a matter of refining them so they don't misfire. And then it's a matter of understanding how to condition them to make appropriate use in various applied areas. Okay? That's what it's all about. So, my synapse is hurting, says Jay. No, don't worry, young black economist. I think that's such a good insight about how you can measure heart rate, but that always isn't related to someone lying. And that was exactly the point I was making. The variables in cognition are such that the unreliability of lie detector tests is prima facie. So on its face, there's never going to be an argument that they're reliable, because you cannot control for the unique emotional and psychosocial cognitive state of a human and then weigh it against a objective or subjective baseline. You can't. Not their baseline, not someone else's baseline. You can't. There's too many variables. You cannot say cause equals effect. It's never going to happen. All right, so Nunya was like, damn it, man, I'm just a towel. Social Change Warrior says, and who do you think are fake towels? What does that even mean? Grant is always welcoming to everyone in his chat, even if they don't agree with everything. Okay, so I'll explain. Can I smoke a cigarette during the polygraph? Sure, why not? You can be like Mimi Bobek in that episode of the Drew Carey Show. So let me answer your question, young black economist. I think it might have been Social Change Warrior who asked the question. Social Change Warrior asked it. Let me give an answer to this, and then we'll watch this video. So here's how I would explain it. The concept of a towel started as somewhat of a joke. In like 2024, very early, someone was like, Grant thinks his pronoun is towel. And I was like, fine, you know what? I'm just going to become a towel. Now, I wanted to become a towel for a few reasons. One, towels are very fluffy and soft, and they're absorbent. And the towel from South Park named Towely, he's like, I don't know, he like inadvertently solves complex social problems, and he's a little naive, but he's also just like a little towel, all right? So I was like, screw it. That's great. And then I found out Hitchhiker's Guide to the Galaxy has towels as well. Towels seem to be some symbol for like absorbency. I don't really understand it, but the point is I'm a little towel. Now, what is a towel? A towel is someone who lives by an authentic sort of commitment to self and principle, and who's willing to be wrong in order to find truth. So it's like someone who values safety, country, God, family, and academics, and any combination of those. Someone who does so without fear or favor. Someone who's willing to show compassion and unconditional love. And basically it's like my vibe check of them. If like I sense that even if we disagree, they're coming from a good place, then they're a towel. If I openly label someone not a towel, it means they definitely failed the vibe check. If I say someone is on their way to being a towel, it means that they like understand, but they haven't fully embraced the way of the towel. So thank you, Social Change Warrior. I agree. Oh, who doesn't love a good soft towel? I agree. Towels are versatile and very useful. All right, so, and that was kind of what I was explaining. You know what I was saying? You know what I'm saying here? I was trying to use the towel motif as an explication for who I have discerned to be working in line with the principles that I value as enabling cogent public discourse and thus warding off the usurpation of a representative form of government. I'm an American towel. I hate the damn commies. I hate governmental corruption, and I think one bad apple spoils the whole bunch when it comes to due process and civil rights violations, and I'll be damned if I'm going to let it happen on my watch. Not happening. Hi, Nicola Cox. It's so great to see you. Jay, no trivia for the time being. We might play a little bit of trivia for before lunch, but we have videos to get caught up on. I had a specific request earlier, by the way, from someone who asked me to explain. Let me see it. Someone, oh, by the way, these are the TurtleBoy filings that just went up. Cosgrove submitted a motion for leave to late file and to impound the Commonwealth's appendix. The Commonwealth's memorandum in opposition to Attorney Bettero's affidavit in support of motion and associated submissions, and the Commonwealth's appendix to memorandum in opposition to Attorney Bettero's affidavit in support of motion. And then it says, and associated submission, redacted, unredacted, impounded, copy forwarded to Judge Bezos. So it looks like we're going to get this filing. I'm waiting for it to come up on the screen from Dee Dee. However, I also got a question, an erudite and wonderful little question. Oh, do you like my meme that I made of Kate Peter? How hilarious is this, folks who are Team Lindsey? Sir, we've been trying to reach out to you about your towel's extended warranty. And then Benny's like, no trouble now, mister. They call me Benny Sweetpants for a reason. I'm a little towel. All right. We got to find this. Oh, the chat. I found the chart. So I think it was Heather Noss asked me earlier today. What was Heather's question? Hi, Grant. Great work lately. Loving the video outside caught. One question. What is the connection between... What is the connection between Rachel Rollins and Krusty, who is Kate Peter? I get the connection between everyone else, but could you explain that one or point me to your post about it? I'm genuinely wondering. Thanks. Benny is Benny Blanco, Jay. He was in the chat the other day. He's a Kate Peter lackey, in my view. So I said, thank you for your kind words. I will link you a video below, but in short, Rollins and TurtleBoy worked together to take out Joe Kennedy Jr. during a Senate race against Ed Markey in 2020. You might say, why? Well, it was because Rollins, the Biden White House, I think, didn't want Joe Kennedy Jr. to run for the same Senate seat that JFK ran for, because if Joe Kennedy Jr. beat Markey, the 2024 primary would have been Biden versus Joe Kennedy Jr., and the party apparently didn't want that. I think Biden was a bit of a Manchurian candidate anyway, but that's why, like, this liberal Rachel Rollins was teaming up with TurtleBoy to send Rayla Campbell, a Republican operative, to Joe Kennedy Jr. events in 2020 to help Ed Markey. And bada bing, bada boom, in the words of Nunya, what happened a few months after that successful election for Markey where Joe Kennedy Jr. was defeated? Rachel Rollins gets appointed as U.S. Attorney for the District of Massachusetts. And what does she do immediately? Uses a government vehicle to go to Andover for a fundraiser with who? Drum roll, please. Dr. Jill Biden. Yes, ladies and gentlemen, and Rachel Rollins had her own long-standing grudge, you'll come to find out, for bifurcated reasons against the Norfolk DA, Michael Morrissey. Rollins was soft on crime and in a list of 25 or so offenses she wouldn't prosecute. That caused other DAs, including Morrissey, to speak out against her. That led Rollins to start attacking Morrissey in the press. That caused problems. And then furthermore, you're going to come to find out that Rollins filed a brief in a case in 2018 or earlier seeking to have no life sentences for murder defendants in Massachusetts under the age of 25 on the grounds that their cognition had not developed such to make them responsible for punishment that would lead to life incarceration with no parole. Other DAs flipped out, submitted an amicus brief in 2019 or so, 2020. To that case, Rollins was also mad at Morrissey because he opposed her in regards to that topic. Now, Rollins in 2024 ended up vindicated by the SJC, and now the new case law in Massachusetts is that no life terms without parole for youth murder defendants under 25. What are you going to do? We're a liberal state. All right, so moving on to the next topic. It's also even more interesting that the reason Rachel Rollins was fired, and I'm going to talk about it, is in the context of a May 2023 DOJ OIG report. We come to find out, and this has explosive ramifications, that between August and September of 2022, Rachel Rollins was attempting to start a pretextual federal probe to, guess what, interfere in the Suffolk County DA primary between Rollins' ally, Ricardo Arroyo, who is trying to come in to keep up her progressive legacy, against Kevin Hayden, an establishment Democrat who was appointed to fill the interim position of Suffolk DA when Rollins got appointed to the position of U.S. Attorney, who by then Governor Charlie Baker. So Rollins does a bunch of things, we come to find out. She leaks to the Herald, leaks to the Globe, tries to start an investigation that who stops, by the way? Josh Levy and Bill Abley and Dustin Chow all stop Rollins from doing this and cooperate with the OIG, which leads to by the way, Rollins getting hauled before the OIG in November of 2022 and December of that year, wherein she makes material false statements to the OIG about what she leaked to then Herald reporter Sean Philip Cotter about the recusal memorandum about the non-existent investigation into Kevin Hayden that Rollins wanted to leak so that Hayden would lose the Suffolk DA primary. He ended up winning, and he's now the Suffolk DA. In any event, so you can see this pattern with Rachel Rollins, but it gets even worse, because in January of 2023, the DOJ OIG, who I think was Michael Horowitz at the time, but don't quote me, wrote a referral to Biden's DOJ to charge Rollins criminally with misstatements to a federal official under 18 U.S.C. 1001 for Rollins lying to the DOJ in a recorded interview. The OIG, and the Biden White House declined the prosecution referral from their own DOJ OIG. It was inside baseball all the way up to the damn top, folks. You don't understand. This was 1 degree removed from the Biden White House, and it all ties into Rachel Rollins and Michael Morrissey, folks. Oh, my word. Let's listen to this video. It goes for about an hour. Then we're going to read the filing. By the way, it might break into this video if the new filing from Cosgrove that is now up in the docket gets posted by Dee Dee. I seem to be in a mood today. You can see I'm in an announcer towel. We basically could have some kind of auction. Can we auction things? What should we auction? Let's auction Pete Bunny towel. Oh, goodness. He's furious. He says, I cannot auction him. I can auction a date with him. All right. Would anyone like to go on a date with Pete Bunny towel? Pete Bunny Towel, how much can we auction a date with you for? How much do you think a date with you is worth? He would like to be paid in lettuce. Absolutely not. First of all, how are we going to check to make sure the lettuce is safe? What if Kate Peter poisons the lettuce? He says that's a good point. All right, he says he's worth the equivalent of 17 heads of romaine lettuce as to being on a date. Now, I think no, I'm telling you, Christina, he's feeding information back to Kate. No matter how much you like Kate, she's not doing good things. She's just running operatives. She's being a little Kate. It's not okay. Pete Bunny Towel says he's not okay with it. All right? Team Lindsey all the way. Pete Bunny Towel is Team Lindsey. He just wants to let you all know. All right, before we go into this video, by the way, speaking of that, so this was really funny. I do this at a loss. I hope folks understand. I see merit in the work that I do, but I do it a lot. Do it at a loss. Yesterday, as I told you, you can really tell who Kate Peters' people are because they start going at me. And I just want to say to you all, if you're benefiting from this stream, if you find some of these tactics subversive, if you think people are trying to drive people away from this reporting, you're not wrong. But it's not because of me. It's because of the substantive truth and the nature of the connections that I'm talking about. People think that that is a threat to the powers that be. As a result, I want to show you one thing. So, Kate Peter, I think this Mortis Rex guy is one of the Kate Peter people. He's tormenting me yesterday, mocking me. They throw everything they can at me. And he was like, how much in donations did you make today, Grant, or did you do this for free? My response, I did not accept a single donation today, but I'm pretty low after gas and driving to the doctors after court. Anyone who wants to spite Kate Peter and her friends may donate to help Little Towel below. God bless you all. My independent reporting has value, and I am honored to help in the ways that I do. Towel loves America, Towel hates the commies, and Towel is proud of Lindsey. So, before we watch this next video, that's my break. I didn't ask for a single donation, but Kate Peters' friends tormenting me made me realize, yeah, I should put my links in the chat every couple hours. I am willing to lose money and do this at a loss if that those slings and arrows of outrageous fortune are the price that I must pay in order to get folks to understand. But I view that as a badge of honor. So if you want to help Little Towel eat, we're doing this stream, even though I'm going to stop probably sometime before noon so I can eat lunch. And then I got things to do in the afternoon. If you like this reporting, you want to support it, go ahead and support it. Feel free to leave a note as well, and I'll try to reply. I can only reply on some of the platforms when you leave notes. But we're going to watch this explanation, okay, of all of this together. Then if the filing goes up in the TurtleBoy case, we're going to read it. But for now, we're going to watch this explanation. I think you're going to like it, and then I'll drop my links in the chat for donations. The Venmo's at Grant -E1. You'll know it's me because it's a picture of an inflatable Elmo doll. I keep that there because I had a friend named Elmo who's a veteran, and every time someone asks me, is that you with the Elmo doll, I get to tell them about him. It's a plan. Cash App is money symbol Grant Smith Ellis, and then the PayPal is paypal.me/Grant Ellis. God bless you to everyone who does support this work. even no matter how you do it, sharing the channel, reaching out, it all means a lot to me, and that's how I'm able to keep it up. All right, so let's keep the spirits high. Young Black Economist is like, I'm going to teach you all economics whether you want it or not. I'm all about it. Young Black Economist, if you can tell me a little bit, we don't have to do it now, but if you want to come on stream one day, I would love to have a colloquy with you about the evolution of the Hamiltonian banking system juxtaposed to Jefferson's conception of a less federated system for central banking. I'd like to in particular juxtapose it with the system set up by the Bank of England after the war of, what was it, with Spain in like the 1700s or 1800s or something, where England leveraged in perpetuity their national debt in order to get funding. So I'd like to learn about how that evolved into the Hamiltonian system of central banking. Then I want to talk a little bit about Andrew Jackson's sort of the backlash against the first central bank that happened during the bank wars in the 1830s. And then I want to talk about the reemergence of central banking under William Howard Taft's presidency and with Senator Nelson Aldrich and the Jekyll Island Collective in the lead up to 1912 when the Federal Reserve was created. And then I'd like to tie it all together. I don't know how vast I'm not talking about, I guess, economics, but more economic theory. Then when we get to like 1964 through 72, when we look at Bretton Woods and the emergence of the gold standard, and in particular the petrodollar, how does that gel with the preservation of American domestic sovereignty, and how does our monetary policy balance against the interests of sovereign nation states? And does the way that we use fiat lending to facilitate payment of our long-term national debt undermine our domestic decision-making power in furtherance of protecting the financial interests of our creditors? So I'm very interested in all of that, and I agree, Young Black Economist. Well, you are very kind, Allie. As you know, you are welcome to donate to anyone that you want. I think a lot of people have been harmed in their own ways, and anyone you feel is worthy of support, I'm never going to tell you not to donate to them. Not on this stream. I fully believe that it's not a competition. You support the people that your heart tells you to support, and you should feel good about that. Allie, you did miss trivia. We really had fun. Yes, we're going to do trivia. We are not going to do it now. We're going to do it at the end of this video. All right, so now, one caveat. If the TurtleBoy filing from Cosgrove comes in, we're just starting reading it. We already read the Karen Reed filing from the Canton defendants to move the civil case to federal court. It was 7 pages. It was interesting. Now there's a federal case open. I got to go to Pacer. It costs money. I'm upset. I'm an incredulous little towel. Hi, JI5, it's great to see you, my friend. I'm a little towel. If you're just tuning in, our plan for trivia, and Allie, of course, we were talking about you when we were playing yesterday. It was really fun. We were saying, Allie, if we just say Allie and Rue's name and Toffee Towel, maybe they'll pop up. We're going to play trivia probably at 11 o'clock. That's going to take us home today. But the caveat is if the Cosgrove motion goes up during this video, I'm pausing the video. All right? So everybody, buckle in. It's Thanksgiving with Towel, Thanksgiving Eve with Towel, and we're getting ready to watch along. Look at Double Towel. Can you see me aging? I am Double Towel. Yeah, well, FBI, DOJ, listen, if the witnesses sue the feds, that makes things even more interesting, but we're not there yet. We'll keep an eye on it. I think they're really removing because they just want to make the argument, because the comedy provisions, I'm not a lawyer, this is not legal advice, the tension between state and federal law is fascinating. You can have a state court apply federal law. You can have a state court apply state and federal law. You can have a federal court apply federal law. You can have a federal court apply state and federal law. You can have a federal court analyzing whether a state court is the appropriate venue to apply state and federal law. It gets very recursive. Oh, you don't even want to know. But yes. All right. Thank you, Allie Towel. Yes, indeed. And the reason why I was reiterating is I felt bad because I meant to start trivia as soon as you showed up yesterday or 2 days ago. And then I missed the window. And so I've been mulling it over. Anyway, let's watch the video, folks. Trivia coming up at 11 a.m. Eastern. For those of you who want to let your trivia colleagues know, 11 a.m. Eastern, we'll do the call for trivia. I should get a special bell. But this video is going to be interesting, especially for the folks who want to know, now that everything is starting to come out and is on the table, how does this all tie together? And how does this random dude, who's a little towel, sit here, having put this all together months ago? Well, I don't know. I don't know. Thank you, Christina. I'm Team Christina. All right? You could be Team Grant. I'll be Team Christina. And we're all Team Pete Bunny Towel and Team Rue. I like talking to Rue through the TV because sometimes I wonder if he, like, looks up, you know, and he's like, wait. Is that the TV or is that a person? And then I like to think he's now realized that he is just worldwide known. That Rue is a dog, as you know. He's probably like, what? I didn't know that. Yes, you do, Rue. You are clearly a dog. Anyway, Rue's a dog, and he's known around the world, and the TV talks to him. So there you go. JI5, we have to actually get the Cosgrove material. This is Cosgrove's initial response, which is late by 4 days, to Kearney's consolidated three-part motion. This is the 2023 cases involving Jen McCabe and the Alberts and Julie Nagel, etc. 10 of those 16 counts remain against Kearney, okay? 10 of those 16. Actually, it's down to 8 of 16. Aiden has 8 open felony charges, I believe. Okay, this is a tripartite motion. It is a motion to dismiss those cases, those remaining 8 charges. It's a renewed Odell, DiBenedetto, or McCarthy motion to review based on the grand jury being compromised by Kate Peter. Betterow filed a supplemental affidavit to that motion that shows that Kate Peter was having ex parte contact with the Norfolk DA, that more information than anyone realized was removed from Lindsey Gaetani's phone extraction and not given to Kearney. All of this stuff came out. So Cosgrove just doesn't reply for a while because the motion has 2 other parts to it. It's also to take Ken Mello off the case. Oh, God bless you to the person who sent money over for 7-Eleven pizza. I absolutely will do that before I go over to do towel things today. I'm being a productive member of Towel Society. So, but yeah, so the other part of the motion is to remove Ken Mello from the 2023 cases. Mello, before the 2024 cases against Aiden involving Lindsey Gaetani were dismissed, were by the Norfolk DA who no-prossed them instead of complying with Judge Doolin and Judge Krupp's order, respectively, to appoint a new special prosecutor to the case after Robert Cosgrove dropped off the 2024 indictments but tried to stay on the 2023 cases. I wonder who has better connections to the Norfolk DA's office, Lindsey Gaetani or those other witnesses. Anyway, notwithstanding that, that's the primary 2 components of the motion, and it's a really big deal because it has to do, one, when you think about, I'm not a lawyer, this is not legal advice, but the reason I want to read Cosgrove's response is he's screwed 6 ways from Sunday, bro. Forget about the evidentiary penalties under the exclusionary rule and the 4th Amendment and all of that for some of this conduct that the investigators, Tully, Kate, otherwise Morrissey, were doing on the Kearney cases. You now have a situation where under Odell, DiBenedetto, and McCarthy, the grand jury proceeding itself may have been so impaired. Not as bad as with the Comey case, although even that's probably subject to being refiled. I read a very interesting case about even if there's a legal defect in the indictment of someone on the federal level, you can re-indict within 6 months because there's a tolling of the statute of limitations, specifically for the purposes of where there's a flaw in the indictment. It's a statute from 1964. 1823, 18 U.S.C. 1833, 23, something like that. Anyway, so the 3 cases you want to learn about for the integrity of the grand jury proceedings being challenged before a case goes to trial in Massachusetts are DiBenedetto, Odell, and McCarthy. They combine, I call them, those are the 3 big cases. They're like the triumvirate. So you put those 3 cases together and you get what Kearney's argument is. I forget if Betterow and Bradel moved under McCarthy or Odell or DiBenedetto. It depends like what you're asking for. If it's like prosecutorial misconduct, it's Odell. McCarthy is, I forget what McCarthy is, like challenging the sufficiency of the evidence, maybe. The point is they all come together, and what you're really doing is alleging that the indictments should be thrown out and we shouldn't go to trial because there was something that the state did in the ex parte grand jury proceeding that impaired the integrity of the proceedings. Now, those type of things are fatal to cases. If you have Kate Peter talking to the prosecutor, if you have the prosecutor asking Kate Peter to do things, and Kate Peter using the words like, per our conversation earlier, here's what you asked for. Boom. That makes Kate Peter a government agent. Why is that a big deal? Kate Peter's agency in the context of this whole thing means that there is a substantial chance that Betterow and Bradel are going to be able to argue that if there was contact, which there was, between Kate and the DA's office in October, November, December of 2023, when all this stuff was being indicted, maybe through the beginning part of 2024, that means that the proceedings were impaired, the integrity was compromised, and thereupon all the charges should be dismissed. Now, Kearney's asking for an evidentiary hearing, and Cosgrove's opposition means that it looks like we're going to an evidentiary hearing, and you're going to see Kate Peter hauled in, Leah Bathtub Genduso, who knows who else is going to be hauled in. It's going to be one of the most interesting hearings of all time. All right, folks? In any event, let's watch this video. Let's get caught up. Allie, I sleep well as well. And you know what, Allie? Rue may have lost the mayoral election, but I bet he sleeps like a baby. You know what I'm saying? Because he doesn't care what the people think. He has principles. He's a committed politician and also a dog. But you know what? We found out dogs can run for office, so why the hell not? All right, so I guess on that basis, what should... absolutely, Allie. Damn right. You tell him. Hi, Nanya. Good to see you. All right. So I want to circle back, though. So should we do right now? Actually, you know what? Yeah, I'm trying to determine if we should do my analysis of Kate Peter as a government agent or my analysis of the chart. Let's do the Kate Peter as a government agent analysis. You know why? Because that's going to be material to the Cosgrove filing. You see how I'm really smart? I don't mean to toot my own horn, but I meant that. Do you see how it goes to your benefit? I'm not going to make you watch something gratuitously and then just jump in the middle of it to the Cosgrove filing. Let's be intelligent, erudite, and cogent little towels and read the Kate Peter analysis that I did related to her being a government agent, and then let's read Betterow's motion and go from there. All right, so we'll read Cosgrove's response to Betterow's motion when it gets posted, but for now, I want to start with the overview of one of the most important questions, I think, as of right now. Is Kate Peter a government agent for the purposes of the Fourth Amendment, and how will that impact Robert Cosgrove's filing that everyone wants to see? I'm Grant Smith Ellis. Let's watch Towel. Hey, it's me. Oh, I'm kind of cute. Come on. People are like, I think the one thing people have, like, they never say, like, I don't exactly get complimented for it, but I do think I'm a little cute. You know, look at me. I'm a cute little towel. Look at it, especially when I shave and, you know, and I, like, oh, I'm a little pale, but I have a nice jawline. I'm a cute little towel. How can you hate a comfy little towel? Ralph, no, so it wasn't Kate that dropped it. It got posted to the docket. So everyone has it. We were just waiting to read it. So I think Dee Dee probably posted it or whatnot. And by the way, Kate Peter, from what I understand, is not a lawyer. So if she's accessing mass courts or whatever, I think someone gave her a login. The fact that this file was downloaded, that'll narrow the window to help them figure out who's letting Kate Peter use their mass courts login, because only a few people will have this document. Hold on. Ladies and gentlemen, we have a new filing. We have a new filing in the Karen Reed case. Oh, goodness. All right, pause. Michael Proctor is being naughty, apparently. We have a motion to compel. Oh, I'm a handsome little devil towel. A cute little towel. All right, we have a motion to compel. I'm going to Dee Dee's page. Everybody hold on. We got a lot of stuff going on here all at once. By the way, never click any links that Kate Peter posts. So if you can go to Dee Dee's page, or I'll try to put it on Google Drive, always go to Dee Dee's page. Suspicious Sauce on Twitter. I'm going to show you her page. Never, ever. We got it. It's up. It went up 56 seconds ago. Ladies and gentlemen, breaking news. Dee Dee has Dee Dee is where you want to go. Let me show you this. You always want to go to Dee Dee's page, okay? Take a look at this right here. We have it. This is the Commonwealth's response to Betterow's affidavit. Breaking news, ladies and gentlemen. But you always want to go to Suspicious Sauce. Why? A few reasons. One, Dee Dee is responsible. Whatever you want to say about Dee Dee's perspective on the cases, look at Dee Dee's profile, read her replies. She's kind. She's responsible. She never engages in polemics. She's just a good person. So let us have this motion read out. 1 second. Okay. Let me have this motion read out. All right, we're going to listen to the Commonwealth's response right now. All right, so let's look at the front page of the filing. And as I mentioned, Suspicious Sauce on Twitter, thank you very much to her for posting this. So go ahead to Dee Dee's page. You'll be able to see this photo that is now loading up. Now I have I do have a strong chin line, and I'm not overweight. That's very nice of you, YBE. I don't know. I have body dysmorphia, so it's a little hard for me to see what I look like, but, you know, it is what it is. All right, let's get us reading this thing, and then we will talk. All right, it's doing it. Hopefully this one can actually be read. I get very frustrated when they're not compatible. Betero and Bradle normally do a good job. All right, it is downloading. It is done. All right, so let me grab this for you all. Let me get it reading. What's nice is if it does read, it actually scrolls the page for you too. I know, that's like the greatest thing possible. All right, I got it here. I got it. I know, we're all excitable little towels. We all want to hear this. All right. Let's see how long it is. It is 26 pages. Oh, my word. Cosgrove had things to say, little towels. All right, let me get this uploaded. Oh, I'm going to have to pause my camera. Hold on. It needs a certain amount of towel computer power in order to be able to do this. Waiting. All right, got it. All right, it's doing its thing. Now we're going to watch this together. So I have the document. Ladies and gentlemen, I have the document. I repeat, I have the document. We are going to read it together. Okay? So I have to click this button. It's going to take us through all 26 pages, and then it's going to try to read it. Let's see if Bradle and Betero did a good job. I know you did a good job. I have faith in you, Bradle and Betero. Nope. They did a bad job. I'm sorry. You got to make your PDFs, folks. You got to make them OCR compatible. It's not just for me. It is for the disabled people. All right? I'm going to keep speaking up in favor of the disabled people. All right? No disabled people are going to sit here, okay, and do what I'm about to do. Now, I did it for Karen's motion, which was 66 pages. This one is thankfully only going to be 26 pages, so it's going to be quick. But I just want some folks to understand this is not an easy process. If you do not make your PDFs OCR accessible, it is not an easy process. All right. You may also not get this document scrolled. You're just going to listen to it. But if you want to read along, I will go ahead and drop a link in the chat because Dee Dee was kind enough to share it. So if you want to go to Dee Dee's Twitter, that's really the ideal way to get this. Okay, but I'm going to go ahead. This is a very long link. Oh my goodness, it's too long. What kind of link is too long to post in chat? All right, I'm going to post the Twitter short link. Hold on. So this should work. Go ahead and click that link. That will bring you to the PDF. The PDF is now generated into a text file. And now that I have this text file, watch the magic of towel being a towel. All right, so here we go. Ready for this?
Commonwealth of Massachusetts. Norfolk, SS, the Superior Court. 2382 CR 00313. Commonwealth. VV. Aidan Timothy Kearney. This case is specially assigned to Judge Bolezos. Commonwealth's memorandum in opposition to attorney. Betero's affidavit in support of motion and associated submissions. The defendant has filed a group of documents supporting an unfiled motion or motions, most notably what is effectively a motion for reconsideration of the denial, in large part, of the defendant's previously filed and decided McCarthy/Odell motion to dismiss. The present defense documents include attorney Mark Betero's affidavit in support of motion, 87 pp. Various exhibits, about 55, and a memorandum of law in support of motions to dismiss the indictments. 30 pp. Functionally, it is difficult to distinguish the Betero affidavit from a memorandum of law, although it also serves the function of informing the court of what unfiled motions it is supporting. Bidero. Affidavit 71, AC. In brief, the defense seeks 1. Outright dismissal of the pending indictments pursuant to Commonwealth v. Adele, 392 Mass. 445, 1984, or alternatively, an evidentiary hearing in support of that aim. 2. Dismissal of the indictments for the Commonwealth's alleged failures in providing discovery, and 3. Disqualification of Special Prosecutor Kenneth Mello. After setting forth these aims, the Bidero affidavit first lurches into a section entitled Background, which is essentially a hagiographic portrait of the defendant as a crusading, heroic journalist, fearlessly pursuing the truth, exposing the Agami RPFUME Pitha's witnesses in the Karen Red case, laying bare the corruption of local and, Fort Hobik, HWONLUAN assisting the attempts of TEMIRACINAMIT. Bull. EAKIT TE. The forces of evil, aka, the Norfolk County District Attorney's Office, to deter him in his courageous and never-ending battle for truth, justice, and the First Amendment. In reading Bidero's encomiums to Saint Coney, one is irresistibly reminded of Oscar Wilde's comment on the death of Little Nell, the virtuous child in Charles Dickens's The Old Curiosity Shop. One must have a heart of stone not to laugh. The Commonwealth has had occasion to respond to such drivel in the past, and with some reluctance, now does so again. Rather than reinvent the wheel, it quotes liberally from its response to the defendant's previous motion to dismiss. Defendant Coney is self-employed, supporting himself via a variety of internet presentations, appearing on such outlets as YouTube, Facebook, X, Twitter. He broadcasts quite frequently, at least 4 times a week, and has monetized his productions in various ways, including selling subscriptions, begging online for contributions, selling t-shirts, etc. He attempts to present himself to the viewing public much as he seeks to portray himself to this court, as an investigative journalist reporting matters of public concern who often breaks stories by conducting investigations into matters neglected by law enforcement. Before viewers' very eyes live on the air. Definite. McCarthy/Adele Mem. 2. The crusading journalist pose is supplemented by assertions of virtuous moral outrage, fearlessness in the face of opposition, and crass vulgarity, as seen, for example, in the opening to his YouTube shows, which begin with an extensive, repeated chant of "I'm going to fuck you up." The indictments against Coney at issue, in the defendant's original motion to dismiss, McCarthy/Odell, largely, perhaps entirely, grow out of his activities connected with the Karen Reed case and its witnesses. Reed has pleaded not guilty to charges of second-degree murder, manslaughter while operating under the influence, and leaving the scene of the motor vehicle accident after personal injury that resulted in death. As recently summarized in the press, the Commonwealth alleges that Reed backed her Lexus SUV in a drunken rage into her boyfriend, Boston police officer John O'Keefe, early on the 29th of January, 2022, after dropping him off outside a Canton home following a night of bar hopping. Anderson, Travis. Prosecutors oppose motion to dismiss charges against Karen Reed, call allegations of evidence tampering baseless. BostonGlobe.com, the 28th of February, 2025, 11:27 a.m. The defense claims that Reed was framed and that O'Keefe entered the house, owned at the time by a fellow Boston officer, where he was fatally beaten in the basement and possibly attacked by a German Shepherd before his body was planted on the front lawn. ID. A subsequent set of indictments against Mr. Coney named a former paramour termed informant for the Commonwealth, Lindsey Gaetani, as an alleged victim. Those indictments have since been dismissed by the Norfolk District Attorney's Office. At some point early in the Karen Reed prosecution, on or about April of 2023, Coney made her the subject of some of his online presentations, apparently drawing a favorable audience response. One person who took note was Natalie Wilk-Buschneider, who had attended Bentley College with Reed from 1998 to 2022 and was now living in California. In February 2022, Wilk saw news articles about Karen's arrest stemming from the death of John O'Keefe, prompting her to contact Reed and offer support. The two women began an ongoing series of conversations covering a number of topics, among them Reed's alleged innocence. Reed sent Wilk pictures of Colin Albert and suggested that he and O'Keefe shared mutual animosity. In April 2023, Wilk spoke with a Facebook supporter of Reed's who told her she had a friend, Connie, who would be willing to cover Reed's story. Wilk asked Reed if she would be interested, and she was. To facilitate communication about the case, Reed instructed Wilk to download a messaging app, Signal, which auto-deleted messages after a certain period. Wilk assumed the role of go-between between Reed and Connie, with Reed sending her information and pictures, and Natalie pasting it into text messages. For Connie, Wilk stated that these text messages included information regarding witnesses, the home address of Trooper Michael Proctor, pictures of witnesses, autopsy photographs, motions filed by her attorneys, police reports, and photographs taken by the Massachusetts State Police, MSP, Crime Scene Services section. In short, Reed passed along through Wilk everything Connie would need to act as a press agent for Karen Reed while feigning the role of a crusading investigative reporter. Reed would sometimes point out mistakes in Connie's blog presentation to Wilk. For his part, Connie would ask questions about court paperwork which Wilk would forward to Reed, who would respond to her. Reed and Connie took pains to conceal their relationship from the public. She would sometimes send him information but tell him he could not put it on the air, typically because it was information that had come to her through discovery, but was not public. Inferably, use of the information would alert this court, and an observant follower of Connie's, if such exists, that she was feeding him information. It is also clear that Reed enlisted the cooperation of counsel in coordinating her information dumps to Connie. Lieutenant Brian Tully's testimony provides a telling example. In mid-May, Connie sent Wilk a picture of himself wearing a t-shirt depicting a Google search bar with the phrase, "How long to die in cold day?" reference to a piece of evidence in Commonwealth v. Reed. Wilk responded, "She will ask Reed if he can wear it to court." Wilk later tells Connie, quote, "TT's okay to wear the t-shirt, how long to die in cold? I got the okay end." Quote. Connie responded, "You asked Alan." An apparent reference to one of Reed's attorneys, Alan Jackson. Wilk responded, "She replied, absolutely. Connie wore the t-shirt at the 25th of July 2023 court date. In early June of 2023 the two women had a falling out. Wilk had provided some encouragement and advice to Connie over a proposed documentary. Upon learning of it, Reed became angry. An argument ensued, and the two women ceased to speak to one another. Wilk was aware, however, that Reed also communicated with Connie through a John Silverer, and Wilk herself had provided Reed with Connie's Signal username so she could contact him directly. Grand jury summons is issued to Verizon requesting call detail records for two of Connie's phone numbers and the phone number Wilk provided. Investigators for Reed, the resulting records showed 189 phone calls between those numbers, totaling over 40 hours. Connie continued to lie to the public about his cozy relationship with Reed, denying in the 29th of August 2023 video that he was communicating with her or her lawyers. Obviously, the telephone was not the exclusive means of communication, as the two were also communicating, for example, through the Signal app. The defense as it developed in the first Reed trial, as tendentiously previewed by Kearney's statements and actions and as it unfolded in court, was something of a murder on the Orient Express defense, everyone in the O'Keefe home on the night in question, as well as the investigating officers and others, either murdered John O'Keefe or was complicit in the cover-up and framing of Reed, who was innocent, as the grand jury could have concluded from the evidence before it. In pushing this theory, Kearney attacked virtually every prosecution witness, including all people present in the house that evening, as well as certain of their family members. He also savaged O'Keefe's family members for their support of the Reed prosecution. In addition to his verbal attacks, the defendant harassed many of the witnesses by means of what he called a rolling rally, gathering a caravan of his followers to drive, seriatim, to the homes of the witnesses where he denounced and taunted them with a megaphone, often exhorting them to tell the truth, which the witnesses understood as an accusation that they were liars. Commonwealth's opposition to defendants McCarthy/Adele motion to dismiss. Hereafter, Commander OPP. Mod #1, pp. 2-5. Argument. Having previously brought and fully litigated a McCarthy/Adele motion, the defendant has no right to bring a renewed attack on grand jury proceedings already upheld by this court. Arguments he previously raised have been considered and decided and are settled, arguments that he failed to raise but could have are waived. On the 14th of February, 2025, the defendant filed his McCarthy/Adele motion to dismiss indictments for lack of probable cause and for the prosecutor's impairment of the integrity of the grand jury with misrepresentations of fact and law. Henceforth, 1st MD, docket #69. At the time he did so, the Commonwealth had provided in discovery to the defendant all of the grand jury minutes. Among other things, he thereby necessarily had full and complete knowledge of the following: that the grand jury heard that Special Prosecutor Mello ultimately did not ask the grand jury to return an indictment against Kearney for illegally wiretapping Mr. Scanlon. All of the testimony of all grand jury witnesses, including Det. Lieutenant Tully. All of the instructions given or not given to the grand jury by Mr. Mello, and all questions and comments made by him. All of the excerpts of Kearney's online media presentations introduced in evidence and how they were identified on the thumb drives introduced as grand jury exhibits. Kearney originally told this court that the prosecutor impaired the integrity of the grand jury by misrepresenting fact and law, soliciting opinion, and distorting the state of the evidence by selective omissions. 1st MD, p. 20. He specifically argued that the Mr. Mello's instructions to the grand jury were deficient, and that he elicited improper opinion and hearsay. 1st MD, pp. 20-24. However, he did not bother to raise any argument concerning the absence of a wiretapping indictment, alleging that Scanlon was a victim, and neither did he complain about the accuracy, completeness, editing, or titling of the video excerpts introduced as exhibits. Undersigned counsel filed a responsive memorandum, henceforth, Response 1, addressing Kearney's arguments, on the 5th of March, 2025. Docket 72, on the 19th of May, 2025, having the benefit of both parties' memoranda, copies of the grand jury minutes, and copies of the online excerpts played for the grand jury by the Commonwealth, the court, Doolin, J. issued a comprehensive decision allowing the motion in part, dismissing 6 indictments as presenting insufficient evidence, primarily those that named troopers as victims, but otherwise denying it. Neither party moved for reconsideration. Neither party sought interlocutory appeal. Now the defendant wants to do it all over again. Writing on Kearney's behalf, Attorney Bidero has made the same arguments, having adduced various examples of alleged sins committed by Mr. Mello, some the same as presented by Attorney Bradel in the first motion to dismiss. He plucks a few different examples, but all of them were readily available in support of the defendant's position in round 1. As one justice of this court has aptly put it, a motion f's not a dry run. or a dress rehearsal, to come back, once an adverse ruling is obtained to try and do it all over again. See Commonwealth v. Pagan, 73 Mass. App. CT 369, 375, 2008. To be sure, a judge may permit a motion that has been heard and denied to be renewed when substantial justice requires. Mass. Arcrim. P3, A, 5, 378 Mass. 871, 1979, emphasis. Added. Such instances should be rare, however, lest, as said in a different context, judges would. 299. Become Penelopes, forever engaged in unraveling the webs they wove. Commonwealth v. Safarian, 366 Mass. 89, 99, 1974, quoting L. Hand, J., in Jorgensen v. York I. Smack. Corp. 160. F.2d 432, 435, 2d Sir 1947, Cert. Den. 322 U.S. 764, 1947. Renewal, however, is typically appropriate where new or additional grounds are alleged which could not reasonably have been known when the motion was originally filed. Reporter's notes to Mass. Arcrim. P13, emphasis. Added. In the Superior Court, a motion for reconsideration shall be based on 1. Newly discovered evidence that could not be discovered through the exercise of due diligence before the original motion was filed, 2. A change of relevant law, or 3. A particular and demonstrable error in the original ruling or decision. A motion for reconsideration shall otherwise raise no new grounds for relief not raised in the original motion or opposition and shall not reiterate previously advanced arguments. Superior Court Rule 9d, Motions for Reconsideration. The defendant's motion for reconsideration flouts each and every one of the 3 prerequisites, which may explain why he shrinks from honestly labeling it as a motion for reconsideration. In his initial motion, the defendant did not attack, as he now does, any of the video evidence offered by the Commonwealth. For his present motion for reconsideration, he now claims that the prosecutor and Det. Tully, 1. Deceived the grand jury by grouping videos the Commonwealth offered as evidence of intent on a folder on the thumb drive exhibit labeled as intent, 2. Showing edited clips that allegedly deprive, the grand jury of viewing Kimi's actual full episodes, many well over 2 hours long, and 3. Assigning titles to the edited clips that did not match the titles Kearney assigned the full episodes. Bideroafid. J 241 to 259, and chart, pp 62 to 64. Although, as the Commonwealth will shortly develop, these arguments have been entirely waived by their omission from 1st MD, it first stoops to briefly address the substance of Kearney's newly raised claims concerning the videos. 1. Tully never testified that Kearney created the thumb drive folder labeled intent, into which Tully placed videos showing Kearney's intent, and no reasonable juror would have drawn such an implausible inference. Moreover, the jurors had available for viewing the video clips themselves and could view them and draw their own inferences as to Kearney's intent. 2. Counsel's use of the term edited to describe the clips is artful in falsely implying that the contents were somehow modified or distorted. Were that so, one might expect the 88-page affidavit to offer examples of the edits, but there are none, and that is because the edits consist entirely of exact clips of relevant content broadcast by Kearney. The only editing is selection. The appropriate course, according to counsel, would have been to show the entire episode for each show, or, by Mr. Kearney's count, over 50 hours of content, prescinding from any question as to whether subjecting the grand jury to such an extended dose of Kearney video would have violated the constitutional prohibition against cruel and unusual punishment. Such a course would have inserted confusing and irrelevant material, and doubtless would have generated additional defense arguments. that Kearney was prejudiced because the Commonwealth presented evidence of other conduct for which it did not specifically request indictments. See Bidero Affid. 29, 264. If one were to seriously entertain the defense's play the whole video argument, a useful way of thinking about it would be by analogy to the trial doctrine of verbal completeness, which holds that where the Commonwealth places into evidence passages from a defendant's statement that it believes support the charge, the defense may then put in such contemporaneous evidence from the same statement which contradict, modify or otherwise throw light on the prosecution's passages. The rule is exhaustively discussed in Commonwealth v. Watson, 377 Mass. 814, 824-834, 1979. In the context of admission of documents, defendants have insisted that either the whole document or no part of it was competent. There is no such rule. JD at 830, quoting United States v. Dennis, 183. F.2D 201, 229-230, 2D Sir 1950, AFFD 341 US 494, 1951. Of course, the standards of a grand jury presentation are less exacting than a trial's. A grand jury is not bound by the rules of evidence that hold at trial. 3. The grand jury hardly could have been misled by the titles Lieutenant Tully used to identify the excerpts he played for them. Consider the specific examples which the defense singles out as misnamed and misleading episodes, i.e., those titled by Tully as Trying to Destroy Colin Albert's life, Life as Normal is Over, and Impromptu Live the 8th of July, 1923, Alberts Should Be Afraid. Bidero Affid. 256. All of those titles were taken from Kearney's exact words, which the grand jurors saw and heard him speak as the YouTube clips were played, and which this court had as exhibits at the defendant's previous McCarthy/Adele motion to dismiss. If there was any 2TN trying to destroy Colin's life, Kearney begins by musing about whether Colin's aunt, Jill Daniels, whose photograph he displays, has a crush on him, a proposition he modestly thought at first to be ridiculous. After asking his viewers to weigh in on this important topic, he opines that it's wild, because JM like trying to put her like godson/nephew in jail, and like kind of like destroy their life, but she also likes me. Like, what? 2 comments. Daniels is not a witness in the Reed case, but as a relative of a witness, Kearney considers her fair game for humiliation. Second, Kearney explicitly states the goal of his behavior with respect to Colin: destroy his life. Commander OPP. Mod P26. In Life as Normal is Over, Kearney shares the screen with a photograph one of his acolytes has snapped of Chris Albert when he was at, as the Commonwealth explained to this court on the previous go-round, in episode 598, Life is Over Now, Kearney taunts Albert, suggesting that he will never be able to go anywhere in peace because there are turtle riders everywhere who will harass him and photograph him wherever he goes. It's only going to get worse from here. Although Chris Albert didn't personally kill John O'Keefe, he raised someone who did it and was helping to cover it up. He adds, Chris, I know where you guys were today. Y'all were in Agawam, weren't you? I got pictures of you in my cell phone. I got people sending me pictures. You guys were at some sort of little league thing in Agawam. Alberts, McCabe's, all you people were there. So like just know that there will be no life as normal is over. Emphasis supplied. In Alberts Should Be Afraid, Kearney assured his viewers that they had nothing to fear from the same Alberts whom he routinely accused of being implicated in a murder. The jury saw and heard Kearney conclude, I'm certainly not afraid of Brian Albert, or Colin Albert, or any of prejudice to the defendant. Kearney himself was the author of it, damned not by sinister manipulation by the Commonwealth, but out of his own mouth. All of the above examples, chosen and singled out not by the Commonwealth but by the Defendant himself via the Bidero affidavit, are illustrative of the truth of Lieutenant Tully's statement that he named the videos to accurately describe their content, often using the exact relevant phrases spoken by the defendant. Tully affid. 49. Also, some of Tully's titles for excerpts were far more anodyne than the Kimi titles for the full episodes from which they were taken. To pose two rhetorical questions, if Tully's purpose were to use the excerpt titles to inflame the grand jury, would he really title the excerpt from EP 580? Elizabeth Proctor Dumbest Wife Ever, Brian Albert Opposition Motion The Bland Call to Elizabeth Proctor. Would he have toned down Kearney's drunken lardo? Michael Morrissey declares war on Turtle Riders to response to the Morrissey statement. But the court need not wade into any of the defendant's contentions about titling of the excerpts, because the defendant has waived the argument, failing to make it in his original McCarthy/Adele motion to dismiss. At the time he filed that motion, he obviously had available to him the full episode names that this time around he has lovingly memorialized in a 3-page chart. Bidero affid. pp. 62 to 64. He had all the relevant grand jury transcripts containing each and every word of Lieutenant Tully's that he now calls to the court's attention, including all the titles designating the clips played for the jury which he previously ignored but now excoriates. He had copies of the grand jury exhibits, including each and every video exhibit played for the grand jury that he now references. No one knew better than the defendant himself what he had titled his original episodes, and that they were lengthy, often well over 2 hours in length. It could not possibly have escaped these punks. They're afraid of me. They should be. I would be if I were them. Emphasis added his attention that the Commonwealth played not the full videos, but pertinent excerpts, that the Commonwealth placed some of those exhibits in an electronic folder designated intent which the defendant obviously knew he did not create, and that the names of the excerpts typically corresponded to their content, not to the titles he himself had given the full episodes. Nobody was better situated to make these observations than the defendant himself. Finally, even straining charity to the point of believing Kearney was oblivious to the obvious. At the time he filed his McCarthy/Adele motion, the Commonwealth's opposition to that motion clearly should have alerted him to the issue in time to raise it at oral argument before Judge Doolin. Attorney Bidero correctly surmises that undersigned counsel had been unaware that the excerpt titles came from Tully, not Kearney, relying as undersigned counsel did on the exhibits introduced before the grand jury. Bidero affid. 244 and N.19. However, for whatever reason, undersigned counsel nevertheless did notice one retitling and scrupulously called it to the attention of the court. In discussing the video excerpt confronting Jennifer McCabe at a lacrosse game undersigned counsel stated that apparently the title was assigned by the Commonwealth. The video comes from a TurtleBoy live broadcast, entitled, Asking Jennifer McCabe That Question. Does she know the answer? Commander OPP. Mod #1, 10p and N.3. Catherine Peters' involvement as an informant in the investigation of Kearney's alleged crimes provides no substantial basis for reconsideration of this court's prior denial of the defendant's McCarthy/Odell motion. Kearney acknowledged in passing the existence of his prior motion to dismiss, but asserts that he filed it without access to undisclosed evidence which he claims was important. Bidero affid. $33. The defense designates two such pieces of evidence. First, communications between Miss Peter, Mr. Mello, and D.L. Tully. Bidero affid. 934, which was critical and if disclosed promptly, would have been included in support of the defense's first motion to dismiss. Bidero affid. 291, and second, the previously discussed presentation to the grand jury of excerpts 10 from Kearney broadcasts that were labeled by Lieutenant Tully. Bidero affid. 936. The defense claims that it learned of this for the first time on the 4th of September 2025. Bidero Afid 936 as fully demonstrated above, that contention is risible. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications among Special Prosecutor Mello, Lieutenant Tully, and Miss Peter, and so has new evidence. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice mass Crim. P13, A, 5, should dictate an undoing of Judge Doolin's previous denial of the defense motion to dismiss. It should not. There is a factual dispute that the court should resolve. The defendant paints Miss Peters as a member of the prosecution team, indeed, the dominant player to whom Special Prosecutor Mello outsourced investigative work. Bidero Afid 191 per Bidero. Mello was supposedly aware that she edited Mr. Kearney's content with her own editorial slant and bias, and reviewed private links she sent him more days before the grand jury proceedings started. Bidero Afid $191. The implication of the latter assertions, apparently, is that Mello and Tully were spoon-fed maliciously edited clips by Miss Peter, which they then mindlessly regurgitated as grand jury exhibits. As Lieutenant Tully's affidavit demonstrates, that is not the case. See, for example, Tully Affid 20-22, 41-45. Miss Peter was not part of the prosecution team, but a source of information among many sources. The primary source of information was the victims of Kearney's broadcasts, who complained about them to the Commonwealth, although to be sure, Peter may also have brought some of that information to Mello's or Tully's attention. In each instance, Tully went himself to the internet, viewed the allegedly offending material, copied it if appropriate, and, if presenting it to the grand 3. On the one hand, the defense is highly critical of the Commonwealth as ignorant or dismissive of Peter's woeful credibility. Bidero Afid 9157, see also, for example, 141. On the other, it never fails to adduce the slightest boast by Miss Peter as to her own importance to the investigation as credible, for example, Bidero Afid FF 193-196, 197. 11. Jury named it in a way that accurately identified its contents, usually using Kearney's own words as contained in the excerpt. Tully Afid #739, 44, 45. The defendant's bald assertion that the Commonwealth employed Miss Peter to clip, edit and rename Mr. Kearney's episodes and then conceal the actual episodes and their accurate information from the grand jury's consideration. Bidero Afid 208, is an outrageous and irresponsible untruth. In but 2 instances, the Commonwealth, of necessity, did use the exact videos provided by Miss Peter because those videos were no longer up on the internet, allegedly because they had been removed. Both were wiretapping claims. One arose in connection with an alleged surreptitious recording of Lindsey Gaetani, which the defendant played on an internet broadcast. The evidence was that the initial version was taken down, and a second version substituted into which Kearney edited from some other source an announcement that he was recording the conversation. Gaetani's testimony corroborated that Kearney never told her the conversation was being recorded, i.e., the initial version, not the second, was genuine. The other Peter recording was introduced during the grand jury presentation involving Mr. Scanlon. At in all, a defendant might well contest the authenticity of these, or any, recordings, but here the Commonwealth had a good faith basis for believing them to be accurate, based on the statements and testimony of the involved witnesses. See, for example, Bidero Afid 4217, citing the 28th of November 2023 GJTR. pp 14-15, Scanlon claimed that Kearney told him he wouldn't record their conversation. There was no impropriety in their introduction. Were the court to conclude otherwise, however, the proper remedy would be the dismissal of the resultant tainted indictments. That is unnecessary. The Gaetani indictment is not before this court. It was never part of 2382 CR 00313, and in any case, has been null prost, for unrelated reasons, by the Norfolk District Attorney's Office. Neither is a Scanlon indictment before this court, for as the defendant has complained repeatedly, the Commonwealth did not ask the grand jury to return 1:12. As for the indictments actually before this court, to the extent she and Mr. Kearney share a mutual loathing, and they clearly do, and to the extent to which she may desire to see him hurt, humiliated, and imprisoned, and she apparently does, the question for the court and ultimately a jury, should a trial judge permit counsel to go down that particular road, is not the bias of any particular informant, but the reliability of the evidence. The Commonwealth's evidence before the grand jury consisted of videos indisputably made by Kearney documenting his own actions and the testimony of his victims as to their knowledge of those actions and the impact they had on their lives. It matters not a whit who informed the Commonwealth of any particular video's existence. What matters is the authenticity of the evidence. For all the relentless characterization of Tully's labeling of the video excerpts shown to the grand jury as improper Bidero Affidavit 9251, intentionally misrepresented out of context, cherry-picked snippets 9253, prejudicially named 254, false, lie, name, D, 9255, misnamed 1264, sliced and diced, definite, mem. P9, cherry-picked, and out of context and subterfuge, that, tricked the grand jury, definite, mem. 10p, nowhere. Nowhere does the defendant point to even a single word of Kearney's in any video clip that has been altered or modified by the Commonwealth. Nowhere does he point to a single instance where a word was omitted altering a meaning, and nowhere does he represent that he did not create the videos of his own actions and words shown by the Commonwealth to the grand jury. He does not make those representations because he cannot. At the end of 30 pages of memorandum of law, 88 pages of meandering argument mislabeled as an affidavit, and a host of exhibits, the defendant's contentions amount to nothing more than sound and fury signifying nothing. The Commonwealth has provided the defendant with extensive discovery in this case, whatever the problems or flaws in its production of discovery, and there have been some, they fall far short of requiring the draconian sanction of dismissal of the case. The Commonwealth promptly provided the defense with extensive discovery, as borne out by the items set forth in undersigned counsel's letter to Attorney Bradle of the 8th of May, 2024, also notable for 13. Its expression of undersigned's belief, naive in retrospect, that discovery was then almost complete. This court should take note of discovery itemized in that letter, the subsequent discovery letter of the 13th of June, 2024, and indeed the Commonwealth's filed and docketed responses to the defendant's previous discovery motions, in measuring the veracity of the defense's claim that since Mr. Kearney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory, obligations to disclose evidence to the defense. Definite. Mem. P21. Discovery has continued since that time, with the Commonwealth responding to defense requests, and the defense, in turn, finding problems with the discovery provided, alleging missing discovery. Sometimes correctly so, continuously generating new discovery requests, and demanding further explanation of discovery already provided. Some of the Commonwealth's problems have been logistical, which are not the defendant's fault, but inform the realities of production. By way of background, the investigation into Kearney began about May or June of 2023. Tully Affid One attorney Mello, a resident of Bristol County, was engaged as special prosecutor on or about September of 2023. Tully affid. 6 months later. In March of 2024, the Norfolk District Attorney recruited the undersigned to assist Mr. Mello with some legal research, writing, and similar tasks. Mello, however, proved to be gravely ill and has been physically unable to appear in court, requiring the undersigned effectively to assume full responsibility for the case. In point of fact, the undersigned has never been able to meet with Mr. Mello in person since undersigned counsel's entry of an appearance in any case against Mr. Kearney. Cosgrove Affidavit 43-4. While counsel has largely been able to obtain discovery materials directly from the Norfolk District Attorney's Office, some of the necessary materials have been in Mr. Mello's possession, and his ongoing health problems and intermittent hospitalizations have retarded the process of acquiring them. See, for example, Cosgrove Affidavit 16. To return to the previously mentioned the 8th of May, 2024 discovery letter, the court will note that in addition to the discovery produced by undersigned counsel, it references discovery previously provided by DT Lieutenant Tully, given 14. Mello's illness, then hoped to be transitory, Tully was employed in the prosecutor's normal role of providing discovery. Another difficulty with discovery in this case has been the ongoing nature of the defendant's conduct toward the alleged victims and witnesses. To reiterate just a few previously brought to the attention of this court or others, there was his online hope that Lieutenant Tully would die horribly, along with his wife and children, charmingly coupled with Kearney's self-comparison with Jesus, his nose to the window antics and accusations in the form of questions at the Albert's Pizza shop, captured by their security camera, his recent drive-by outside the Cape Cod home of a witness in the Karen Red case, his discourse as to whether or not an officer's wife was blue because, Kearney speculated, she gave her husband oral sex, and his repeated libels of Jennifer McCabe as a murderer. These, and a host of other antics, some relatively minor, some offensive but clearly legally protected speech, prompt the victims to contact the district attorney's office, often by email, questioning whether action can be taken, whether the conduct is a bail violation, etc. Arguably, these constitute discoverable statements although they say nothing whatsoever about the crimes with which the defendant is charged. To the extent they provide information on subsequent bad acts, the Commonwealth would be obligated to disclose such bad acts in any case before attempting to admit them at trial. If statements are otherwise arguably discoverable, it is because they show a bias against Mr. Kearney that conceivably could be used to impeach him, but the reasons for any victim's bias are obvious from the very facts alleged supporting Kearney's charges. In that sense, discovery of the statements is entirely cumulative. This court should consider limiting discovery going forward to exclude victims' statements that make no factual references to the underlying charged offenses or to prior or subsequent bad acts that the Commonwealth seeks to introduce at trial. Otherwise there will be no end to it. As it did with its attack on the grand jury presentation, the defense focuses much of its criticism on the Commonwealth's provision of discovery concerning Catherine Peter, which, it 15. claims, support its preposterous theory that she, Lindsey Gaetani, Mr. Mello, Det. Lieutenant Tully, and possibly others diabolically plotted to have Mr. Cleary's bail revoked by luring him into intimidating Miss Gaetani after they made her what Mr. Bidereau describes as a witness taking. Care to put the term in scare quotes. Discovery provided by the Commonwealth shows that Gaetani was indeed a witness, interviewed by the police with specific attention to what she knew about Kearney's ongoing communications with Karen Reed. After that interview, she received a summons to testify before the grand jury. Like so many other issues, the defendant has raised this one with this court before. The Commonwealth picks up the story by quoting a previous response. In abbreviated form, the Commonwealth summarizes the evidence. largely drawing on Ms. Gaetani's testimony before the grand jury, supplemented by police reports and other evidentiary materials, all of which have been provided in discovery to the defense. Ms. Gaetani met the defendant in September of 2023 after viewing his blogs and YouTube shows dealing with the Karen Read case and ordering a t-shirt from his website. The relationship became intimate. By the beginning of December, the relationship had soured. Gaetani came to the attention of Special Prosecutor Mello, who dispatched Det. Lieutenant Brian Tully and a specially assigned private investigator, Nelson de Gouveia, to interview her. As a result of that interview, the detectives returned to Gaetani's home on the 22nd of December, 2023. Upon receiving the summons, Gaetani feared that Kearney would think she had sought out the detectives and was trying to get him in some sort of trouble. She was afraid he would retaliate in some way. She called Kearney and sent him a picture of the summons. Hours of phone conversations and text communication ensued. Kearney became upset and accused Gaetani of setting him up by passing along information to Kate Peters, a woman who, he believed, was averse to his interests, and had provided the information to the police. The following day, the 23rd of December, acting against what he had told Gaetani was his lawyer's advice, Kearney announced that he wanted to come by Gaetani's apartment to discuss the summons. Gaetani agreed. They met first at a business conference room in her apartment building. Upon arriving, Kearney demanded that Gaetani give him her phone. He said he wanted to read any messages between her and Peters, as well as any messages with Detective Lieutenant Tully and Special Prosecutor Mello. Gaetani refused. The defendant then threatened that his lawyer was going to have to destroy her on the stand, tear apart every piece of her life, embarrass her, bring up everything from her past. Stalling for time, Gaetani went into the bathroom and telephoned Special Prosecutor Mello and spoke to him briefly. Mello called Lieutenant Tully, told him Gaetani said that the defendant was 16 in her apartment, and forwarded her call. Tully could not understand anything she said as the voices were muffled inferably because Gaetani did not want the defendant to overhear. After several minutes, the call ended, and at 10:48 p.m. Gaetani sent Lieutenant Tully the following text message: "Ken said to call you but I can't, he's knocking on the bathroom door. I have to go back out. Please don't text or call and tell Ken not to because he wants to see my phone. I'm deleting our calls and texts right now. Don't respond until you hear from me, please." Gaetani emerged from the bathroom and unsuccessfully attempted to stall, showing the defendant her phone. Terrified by the defendant's threats, Gaetani acquiesced, and the two proceeded to her apartment. In the course of the conversation, the defendant instructed Gaetani to delete from her phone messages between the two of them. He said that I would not get in trouble if wanted to throw my phone in a river or delete any messages, because with this summons there was no order for preservation of evidence. So he said I could not get in trouble for removing any incriminating information from my phone about him. He said that he confirmed this with his attorney, Tim Brad. For the next several hours, the defendant went through Miss Gaetani's phone, reading through exchanges between Gaetani and Kate Peters, and taking notes. At the conclusion of this process, the defendant announced that he was very proud of her and was going to protect her. The reconciliation, such as it was, did not last long. Later, while the defendant's attention was elsewhere, Gaetani ripped the page of notes that he had taken from his notebook, crumpled them, and shoved them down her shirt, and subsequently hid them under her mattress. Footnote: omitted. The defendant became aware that his notes were missing and demanded them back, accusing her of stealing his property. Eventually, he announced he was leaving, and after some delay, did so. Gaetani recounted these events the next day by telephone to Lieutenant Tully, who told her to call the Meadfield police to report the incident. Tully perceived her to be hesitant. He called the Meadfield police, reported what Gaetani had said, and asked them to follow up. The defendant has complained repeatedly that the phone texts of that evening between Gaetani and Tully were not included in the subsequent copy of the download of her phone provided them by the Commonwealth. Undersigned counsel explained why that was the case in his letter to Attorney Bradle of the 8th of May, 2024, telling him in pertinent part, if there is data missing. That is, because it was missing when the phone came into the Commonwealth's possession, custody and control, and thus we do not have it. The Commonwealth later secured the missing texts with Tully. 17. By means of copying them from his cell phone, and handed them to counsel in open court during a hearing. So in sum, the defendant wishes to tell a jury that the Commonwealth engaged in a plot with Kate Peter and Gaetani to make her a witness, then lure him to her apartment, provoke him to criminal conduct, then arrest him so his bail could be revoked. So cunning were the alleged plotters that Miss Gaetani studiously avoided any mention of their plot and its apparent progress when texting Tully, nothing like, it worked or he's here now, arrest him. Oddly, neither Tully nor any other officer was outside Gaetani's apartment, waiting to burst in and arrest Kearney at the appropriate moment, and not incidentally, protect Gaetani from any harm. Equally oddly, Gaetani never reported the incident to the local police the following day, a lapse that prompted her alleged co-conspirator Tully to make the call. Truly, this defense theory is Lincolnesque, at least in the sense that Lincoln has been quoted, likely falsely, as saying, you can fool all of the people some of the time, and some of the people all of the time. So, yes, obviously the defendant is correct that the Commonwealth thinks little of his theory. But indulging the defense's contention that the Peter discovery was required irrespective of the Commonwealth's subjective belief in the reliability of the evidence, and further assuming arguendo that its conspiracy theory would be an admissible defense against the now dismissed Gaetani indictments. How probative is it of the indictments before this court, where Gaetani is not a victim? The video evidence against the defendant was the product of his own hand. Kate Peter did not organize, participate in, or induce the defendant to organize, participate in, film, and broadcast the rolling rallies in which the defendant led a caravan of cars to the doorsteps of witness, harangued them and intimidated them using a bullhorn. Neither did Kate Peter compel the defendant to dox and defame witnesses and their family members. The defendant did that all on his own. And a copy of Lieutenant Tully's recorded call was provided to the defense in discovery. 18. To what extent has the defendant been prejudiced by any delay in disclosure of the Peter discovery, as he repeatedly asserts? If prejudiced at all, he has not shown it. The defendant also has a related complaint concerning discovery concerning Miss Peters, i.e., the Commonwealth's alleged failure to preserve exculpatory evidence. The Commonwealth provided in discovery various emails sent by Ms. Peter, some to Mr. Mello, some to Lieutenant Tully. Certain of those emails contained links, usually, judging by label or context, to various online broadcasts by the defendant. Tully's general practice, by no means exclusive to him, was not to access links in unsolicited emails sent from parties outside the NDA's office / criminal justice network. Mello, on the evidence of one response to a Peter email suggesting he was unable to access the content, apparently did zero, at least on some occasions. The emails remain, but not all of them have links that are active. They have not been successfully accessed by undersigned counsel, and Tully and defense counsel also report that those links are dead. Why they are dead is wholly speculative. Possibly the path expired of its own nature, or was removed by the sender. None of the emails at issue contained any warning to the recipient that the links were time limited. The factual scenario raises some novel legal questions. For example, what duty does an agent of the Commonwealth have to access an unsolicited link, conceivably exposing computer networks to malware? If the link, which is essentially an electronic path to another document, is not accessed, was the unaccessed document ever in the Commonwealth's actual possession as expressed in definite mem. At 28. If the link is accessed, absent some notice that access may become unavailable in the future, does the Commonwealth have an obligation to attempt to preserve the contents of the link in some other form as a precaution? Does that obligation, if it exists at all, vary depending on the contents of the link? For example, if someone sends an unsolicited email saying that a defendant looks a lot like Humphrey Bogart and attaches a link to Casablanca, is it sufficient simply to save the email, or must the Commonwealth download and preserve a copy of Casablanca? Does the content 19 of Casablanca constitute part of the statement of the witness, or is the statement simply her own words, or her own words and the fact of her attaching Casablanca, irrespective of the film's actual content? Where the link goes dead without any action by the Commonwealth, has the Commonwealth lost evidence or destroyed it? Finally, if someone forwards another email, or a newspaper article, without adding any content, or alternatively, adding neutral content, such as FYI, does the mere act of forwarding it constitute a discoverable statement? If the defense has pondered these issues, it gives the court no hint, proceeding immediately to the assumption that much of the undisclosed and now destroyed evidence was favorable Gileo material because it undermined Miss Peters' credibility, demonstrated her bias against Mr. Kearney, and supported the defense's theory of a shoddy, bad faith investigation. Definite mem. At 28. Given the difficult nature of the novel legal questions raised above, the most useful line of analysis may be to assume, arguendo, that the Commonwealth had a duty to access the links and to take some measure beyond preserving the emails that contained them as a prophylactic against their possibly becoming dead links. The court can then proceed to more familiar questions, i.e., was the evidence once available at the links favorable to the defense? If so, how damaging was its loss, and in light of the damage and the Commonwealth's culpability, what should be the remedy? Under Brady v. Maryland, 373 U.S. 83, 1963, even after the court is satisfied that the Commonwealth lost or destroyed evidence, the defendant is not entitled to relief unless and until he first establishes to this court's satisfaction a reasonable possibility, based on concrete evidence, rather than a fertile imagination, that access to that evidence would have produced evidence favorable to his cause. Commonwealth v. Neal, 392 Mass 1, 12, 1984, quoting State v. Missioner. 25 or App. 523, 532, 1976. Here, the defense asserts that the missing evidence was favorable because it allegedly demonstrated bias by Miss Peter, and supported the defense's theory that the shoddy, bad faith 20. investigation relied upon a civilian who despised Mr. Kearney and had a documented history of falsifying evidence against him. Definite mem. 28. But none of that is true. Given, as the defense says, Peter's cooperation with the Commonwealth and her dislike of Kearney, it hardly seems probable that she sent links to evidence she thought exculpatory. The reasonable and probable inference is that she sent links to Kearney's own broadcasts, which she thought to be inculpatory and pertinent to existing or possible charges against him. Thus, the defendant wisely makes no argument that the content of the missing links is exculpatory, but fiercely asserts that they demonstrate her bias against Kearney. The inference must then be that bias is demonstrated either by the content of the messages containing the links, but note that the defendant quotes none, or the mere fact that Peter was providing evidence to the Commonwealth, even if that evidence were probative of guilt. But there is nothing damning in any citizens assisting a police investigation by providing information. Rather, Miss Peters' lack of credibility, if such there is only demonstrated by the defense's parade of her prior antagonistic statements against Kearney and what it terms her documented history of falsifying evidence against him. Definite. Mem. 28. None of this comes from the lost dead link evidence. If, unlike here, a defendant meets his threshold burden as set forth in NEA, the court then applies a balancing test to determine the appropriateness and extent of remedial action. The court must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Commonwealth v. Willie, 400 Mass 427, 432, 2000. That test does not require the Commonwealth to prove good faith or earnest efforts to preserve the evidence. Commonwealth v. Olszewski, 401 Mass 749, 755, 1988, SC, 416 Mass 707, 1993, cert. Denied. 513 U.S. 835, 1994, quoting Willie, Supra at 432. However, this court need not proceed to that test. For no consideration of government culpability or materiality need occur unless the exculpatory nature of the evidence is shown. Commonwealth v. Williams, 455 Mass 706, 718, 2010. 21. Should the court disagree, considered in the light least favorable to the Commonwealth, the analysis is as follows. Culpability of the Commonwealth. The Commonwealth delayed unduly in providing requested discovery of certain emails to the defendant. At some point, links in some of those emails went dead, whether during the period of undue delay or earlier is unknown. The Commonwealth has not been shown to have been aware of the likelihood of the links going dead, but it has been shown not to have engaged in any affirmative measures to counter such a possibility. At most, negligence, but no bad faith. Materiality of the evidence, none shown, though relevance to impeachment of Kate Peter is claimed. Prejudice to the defendant, little or none. The Bidero affidavit and definite. Mem. Overflow with purported examples of impeachment evidence the defense already has to introduce against Kate Peter. Should the trial judge allow such evidence against a witness, the Commonwealth has no need to call I to prove its case under the pending counts of this indictment. At best, the missing evidence is entirely cumulative. In supporting the opposite view, the defendant relies on Commonwealth v. Woodward, 427. Mass. 659, 678-79, 1998, which undercuts, rather than assists his cause. There, the Commonwealth failed to preserve from an autopsy a missing piece of an infant's dura that was subject to a preservation order. /D at 678. The Supreme Judicial Court upheld the trial judge in holding that the loss of that evidence, surely more explicitly defined and potentially helpful to the defense than that at issue here, did not justify dismissal of the indictment. JD at 681. The Woodward opinion then cited Commonwealth v. Sinelli, 369 Mass. 197, 210, cert. Denied, 464 U.S. 680, 1983, for the proposition that, absent egregious misconduct or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. If and only if the defendant has satisfied his threshold burden and the court then proceeds to consider a remedy, based on the above analysis, the Commonwealth respectfully suggests that no 22 remedy is required, but again, should the court disagree, surely any remedy should fall far short of dismissal. The defendant's motion to disqualify Attorney Mello need not be addressed, as the issue is moot. Kearney indicated that one request is his never actually filed motion was the disqualification of Special Prosecutor Kenneth Mello. Biddero Affidavit, 1, c. The defendant's memorandum of law, however, while commenting frequently on Mr. Mello's alleged failings, never addresses this request. There is A.I arguing impairment of the grand jury process, and A.2 arguing failure to properly disclose exculpatory evidence, but no .3. Perhaps twixt the affidavit and the remo, the defense decided to abandon the argument, in which case, the court need not rule on it. However, the issue is moot anyway. The copy of Judge Doolin's memorandum of decision on the defendant's prior motion to disqualify Special Assistant District Attorney Mello, paper 99, as forwarded to this office by the clerk, bears the docket numbers of both 2482 CR00043 and 2382 CR00313. Degree. The plain result is that Mr. Mello has already been disqualified on the matters pending before this court, and the new motion to disqualify is superfluous. The Commonwealth has not sought to appeal Judge Doolin's decision. During the early months of Mr. Mello's disability due to illness, the district attorney, Mr. Mello, and undersigned counsel hoped that he would soon recover sufficient health to play an active role in court. Degree. In explaining his decision, Judge Doolin stated that Ada Mello, in receiving communications from a witness while the alleged crimes were being committed, made himself a potential witness in Kearney's case. Apparently, the judge's explanation was insufficiently damning for the defense, which seized the opportunity to recast it for this court as follows: Mr. Mello's involvement in this scheme I.E., the alleged plot to frame Kearney for witness intimidation and have his bail revoked, was so great that it resulted in the court disqualifying him from the prosecution of the 2024 indictments in which Miss Gaetani is the alleged victim. One may look long and hard at Judge Doolin's decision without seeing a statement even remotely suggesting what the defense avers under penalty of perjury. 23. Proceedings, well over a year has passed, and that hope has not been vindicated. Moreover, there is no likelihood that Mr. Mello will be capable of appearing in court in the coming year, either as an advocate or in any other capacity. Bowing to these harsh realities, the Norfolk District Attorney and Mr. Mello have not entered into a renewal of his expired contract. Conclusion. For the reasons set forth by the Commonwealth, the defendant's motion to dismiss, as apparently incorporated in the Biddero affidavit, should be denied, with the exception of the defendant's prayer to disqualify Attorney Mello, which the court should take no action on, as the issue is moot. Respectfully admitted. S/Co. Cosgrove. Roberts.
Alright. I have a lot of thoughts. Let me just tell you right now, this is outrageous. They're going to lose. The state is going to lose this motion. And they deserve to lose. This is a clusterfuck. Oh my God. They're in really deep. Let me try to do this rationally. Let me do it quickly. We're not playing trivia. I have to do things later today. I'm sorry. Allie, if you're still here, I promise you we will play trivia. If not on Thanksgiving Day, people will be busy. If we don't do it tomorrow after dinner, we will play Friday, okay? I think I don't have anything till Friday afternoon. I have doctors Friday. I didn't even know doctors were open on Friday. Let's focus. Oh, my word. My name is Grant Smith Ellis. If you missed the filing that just went up by the state in the Aiden TurtleBoy Kearney cases, the 2023 indictments involving Jen McCabe, Brian Albert, Julie Nagel, etc. Folks, something is deeply, deeply wrong. First of all, I'm not a lawyer. This is not legal advice, and that applies to this entire overview. They're screwed. This before we even get to some of the just blatant falsehoods in this response, let me just tell you, if there's an actual judge that reviews this factual record, first of all, this December 5th hearing is not happening. He needs time Cosgrove has to address the supplemental affidavit because it undercuts everything he says in this motion response. The state is in so much trouble. It's really the Norfolk DA and Kate Peter. This is the big secret. Kate Peter compromised these cases, and the Norfolk DA was trying to kind of slowly unpeel the onion to just isolate, contain what she touched, get rid of all that, and keep anything she didn't. But they're wrong about a lot of the issues of fact here, which are going to imperil this fucking case. This, I'm telling you, this is the most outrageous thing I've ever read from any prosecutor ever filed anywhere. And that's saying something. We just keep upping the bar. This is outrageous. So first of all, let's just set aside the Ken Mello thing. Both sides are agreeing he has ill health and is recused. Just let's set that aside for a second. The key issue here, okay, is one, Lindsey Gaetani is still a witness on the other cases, on these active cases, even though the 2 indictments involving Lindsey were dismissed. Number 2, Cosgrove made this argument from the perspective that Kate Peter only touched evidence used in Lindsey's the indictments involving Lindsey. That is wrong. I don't know if he was withheld information or if he's just misleading the court. There is evidence she was involved in both investigations. Third, Cosgrove is an adverse party in a lawsuit with Lindsey, and he's attacking her credibility in here while buttressing Kate Peters' credibility, and he's wrong about the facts he's using to attempt to discredit Lindsey, and he's wrong about the facts he's using to buttress Kate's credibility. This is like living in fucking bizarro world. Okay? One, the messages from Tully to Lindsey and from Kate to Lindsey that were removed from Lindsey's extraction were from after December 23rd, some of them. Second of all, you just represented to the court that no messages exist between Tully and Lindsey and between Kate Peter and Lindsey that were removed from the extraction. You're out of your mind. That alone is going to bang you up on this whole thing. And then second of all, it's so petty. You try to undermine her credibility about Lindsey's credibility about that, and you're wrong? The gall of these people. Okay, that is one prong of this, okay? The second prong is their whole argument. They spent 6 pages trying to rehabilitate Kate Peters' credibility. Let me just tell you. First of all, they called her an informant, and I know folks are a little confused. Go to page 11 out of 26, page 10 of the document, numbered. Look at this header. That is a section header that says Catherine Peters' involvement as an informant in the investigation of Kearney's alleged crimes provides no substantial basis for reconsideration of this court's prior denial of the defendant's McCarthy-Odell motion. What he's saying there is he's stipulating that she was an informant. And people say the phrase giving information. That is a freaking informant. He tries to recast her over and over and kind of equivocate between her and other people that were sending Tully information. No. We already have the Discord emails where Morrissey was on Kate's server. We have the message where Kate says, pursuant to the call with Ken Mello, Kate will do X, Y, and Z. Listen, they're trying to get this case so that Kate and Mello don't get called into it. And that's why they dismissed the Lindsey cases, because it would have been unavoidable. The only reason, in my opinion, they kept the 23 cases alive was, one, they want to keep pressure on Kearney, and two, because they think they can make it so that Kate and Mello won't come up in that context, and they think they can keep Lindsey out of it. That's why they freaked out when Lindsey started providing information to the defense, because Cosgrove filed this motion, notwithstanding everything that's been coming out on social media. And if the judge gets wind of what Lindsey's been posting and the evidence that exists that contradicts Cosgrove's statements of arguments and statements of fact and representations in this motion as an officer of the court, the least Cosgrove has to worry about is these getting dismissed. They went all in for Kate Peter here. And mostly Tully, but Kate Peter, listen, she's way high. She's way more important to all of this than anyone's realizing. You don't do this kind of stuff. You don't do this kind of stuff unless you're going to bat for your person. And you don't go to bat for Kate Peter over 6 pages more for no reason. It's because they're trying to, the state, Norfolk DA through Cosgrove is trying to carve out areas of this case that Kate didn't touch. Oh my God. That alone is a huge violation. I don't know if folks understand. That's almost as bad as possible, because it means you know that Kate was involved in the 2023 cases too. You're just hoping that doesn't come out. And it did. So just his Cosgrove's, and the other thing is Cosgrove citing cases about the interpretation of Rule 14 from before the changes to Rule 14. He's citing stuff from like 2008 or something, 2003, where was it? When we actually get to the legal argument, right, when he's talking about the novel legal question of what he has to turn over about Kate, and then he starts talking about Casablanca. I love the movie, but it's irrelevant. Kate wasn't sending Tully messages about Casablanca. Kate wasn't calling Ken Mello about Casablanca. They were out. Kate wrote an email that's now out there. That's why he's fucked. Cosgrove is fucked 6 ways from Sunday, because Kate sent an email to Mello saying, pursuant to our conversation, here's a legal strategy to pursue with Kearney. Bro, she wasn't sending him Casablanca. If Kearney didn't get that in discovery from the state, and he got it from Lindsey, because Kate sent it to Lindsey for some stupid reason, because Kate doesn't think a lot, in my opinion. That's it. Ball game. Because that fundamental prong of the whole argument, pages and pages and pages, it falls down. My word, it wasn't innocuous. And it's not just exculpatory. The question before the court is not, it's not just that 2-prong test. Rule 14 was amended. So when he's citing Commonwealth v. Willie from 2000, Commonwealth v. Oleski 93, 94, 2010, fine. The changes to Rule 14 went into effect in March of 2025. Yeah, March 1st or something. So what are you talking about, Cosgrove? They're going to lose this motion. I don't know how badly they're going to lose it, but let me just tell you, I can read between the lines here. The thing the state fears more, the Norfolk DA fears more so than anything else, is Kate Peter having to take the witness stand. Wow. I mean, I'm somewhat just shocked, because that's what it all comes down to. The prosecutorial misconduct wasn't necessarily Tully. He was just an intermediary. It was Kate. These cases can't survive Kate having touched any evidence that gets before a jury. That's what this whole argument is about. You got to really, really cut through it. But part of it was about how Lindsey was being used as an unwitting honeypot. But more of it is how Kate's role was hidden. And so they don't even like disclosing it in here. Look how passively they talk about it. Kate being an informant. They're like, oh, well, she provided information like anyone else. Bullshit. They're hiding the stuff about Marty Kraft. I know it. Bro, she can bring they went to bat for her. Listen, how Betterow responds to this. Does he get like a reply to that? Does he get a sir reply to their reply? How Betterow responds? Listen, Betterow's going to tear this apart. And listen, I am unbiased here. I call it like I see it. Betterow is going to rip this to fucking shreds. Okay, first of all, if Betterow didn't have the new information that he had, he would have ripped this to shreds. What Betterow has that's been come out online alone, not to mention the stuff in Betterow's supplemental affidavit that Lindsey turned over. Ball game. Ball game. I don't even know what ball game means here. What do you do in this case? Listen, I think I've learned that if this is really bad, they're just going to null pros it, okay? But the thing with null prosing it is, all of this is out there now. Why didn't you just null pros it before making this fucking argument? It must have been because Cosgrove had this written before all this new information came out about Kate's ties to the Norfolk DA. It's over. You may as well null pros it. You cannot come back from this. Forget about wheeling and dealing with Kearney. You cannot come back from this. You cannot win. At all. And I want folks to understand that's the big secret. It was that Kate has a lot of power because she was an informant for the Norfolk DA and the MSP, and they were protecting their case, and they kept having the situation where if they revealed what Kate was actually doing, none of this stuff could have got to trial. Eventually, they probably were like, oh, well, we can null pros Lindsey's charges, and that way maybe Kate won't get called as a witness. Bro, how can you be so bad at life? Know the fucking factual record. You know what your fucking people were talking about. Oh my God. I'm baffled. This is so bad. This can't go before a judge. What are they going to do? What are they going to do? Well, Your Honor, when we wrote that motion, I guess that email fell under the chair. The one from Kate Tomello. It just fell under the chair, Yeah. Oh, and when we said that Lindsey deleted the messages, we meant that it was actually Tully when he had the extraction. He forgot to click a button. What the fuck are you going to... This is outrageous. I mean, it looks... See, the thing is, it's a little, there's some obfuscation here, because it looks like this, erudite, flowy, what did he cite to? This man was citing everything from Casablanca to the guy who wrote The Ballad of Dorian Gray, Oscar Wilde, or whoever the hell he was citing. This man was taking us on a history trip, all right, through the 19th and 20th century. No disrespect to him. I like history as well. You don't have to quote fucking Oscar Wilde, bro, in a motion in 2025. You don't have to fucking... What else did he fucking reference? Casablanca. You referenced it 5 times in a single fucking paragraph. Not necessary. It looks... What's really funny about this motion is it looks erudite. But it's substance. They're going to get torn the fuck apart. Forget about on the misnaming of the videos. That's not the sum and substance. What this makes me realize is you got to start page 10, section edit. That's the whole thing. The whole kit and caboodle is whether Aiden's earned reconsideration of his previously denied McCarthy and Odell motion, which I talked about before the stream. There should be a hyphen after Odell, after O there in Odell. Because of new information about Kate Peter. Oh, this is so brutal. These people are brutal. They saw this coming. They were like, oh, he's going to do a renewed McCarthy and Odell motion and we can preclude it. Our best argument will be if we just argue mootness because the Gaetani charges are gone and Kate maybe handled information in that case, but, we'll just argue it's moot. Oh, bro, and then you make this argument and then he takes forever to write based on the timing. He was late. So Cosgrove makes this argument, and then as it's all prepared, he's got to be he had this ready at the beginning of this week, getting ready to file it. All this shit, it's the internet, and they're in this position where they're like, what the fuck, do we file this? We're 4 days late. That's why they waited 4 days. They were like, we can't file this. And they did anyway. Oh my God! Listen, they must be so committed to Kate Peter. You just tanked this whole case by filing this, folks. They should not have done this. Because again, this you have to think after the fact. All of this new information is out there that's in Bettero's supplemental affidavit that just, not to mention what's on social media, that eviscerates the core prong of this argument, which is whether or not Kearney's entitled to reconsideration of his prior motions to dismiss under McCarthy and Odell, which, as we know, if you were here earlier, has to do with... Forget members of the prosecution team, bro. You got to think about Rule 14's reinterpretation and what that means about people in the orbit of the prosecution team and PIs and informants and all that shit. Cosgrove didn't even disclose that she was working for Marty Kraft as a PI. She's not a civilian. Bettero got that wrong. She's a PI who's registered. I don't know if she was working with a license or under a license. She was a PI for Marty Kraft, who knew Tully. This whole case hinges on, oh my God, that's why they're all losing their mind. It's Kate. It's all Kate. Aiden may be a beneficiary of some of the attacks against Lindsey right now. I don't even know if he sees how many people are actually working for Kate who are pretending to like Aiden. That's one possibility. My point is, it's all Kate. These cases hinge on Kate Peters' involvement being disclosed with all the related to all of this. And the way, I don't know what Cosgrove is going to do, because his entire argument is that he didn't have a duty to disclose anything more to Kearney, or anything about Kate Peter or her role related to anything, because basically Cosgrove's arguing Kate was really only involved with being an informant for Lindsey's cases. I'm paraphrasing. That's his argument, okay? But the problem is, if there's an scintilla, an indica, small indication of evidence that Kate was an informant related to the 2023 cases, then this whole argument collapses, and that's the evidence that fucking came out after this motion was drafted, clearly. They're pot committed. So why would you submit this? Why would you have him file this on the 24th, 25th, when all this shit came out over the last week? This is crazy. I can't believe this document was filed. I cannot believe it. It's already undercut. This document is moot. Not just moot, it's exposed. Reading it, I was like, oh no. Oh, you didn't just say that. Oh no, he did it again. Like, oh my God. He's going to lose all credibility. If this new judge on the Kearney case, is down the middle, the DA is screwed. All right, because immediately Cosgrove's going to lose all credibility. I realize I know this fact pattern pretty well, so it's going to be, you really got to get caught up if you're a judge on this case. I'm just an independent observer. I'm not a lawyer. This is not legal advice. Cosgrove made at least 5 to 6 material misrepresentations, inadvertently, I don't know, to the court here. All right, at least 6. At least, and they're substantive. And almost all of them are related to Kate Peter. And I now see it. Oh, I'm fucking pissed. Because I should have been able to fucking see it earlier. It was... First of all, these people don't know how fucking Rule 14 works, so they're not even doing this right. Their whole plan was to try to keep as much evidence away from Kearney as possible in the court, so that charges could survive, even stuff coming out about Kate Peters' role in handling evidence. That's why they no-prossed the Lindsey cases. They used the cover of the suit and all this other shit, but it was that. Now, you see why they're pot committed? They really want to save these 2023 charges. So they have to say, oh, Kate wasn't involved in that. After you make that argument, stuff comes out about her being involved in that. No, you can't. I'm sorry, you can't come back from it. Forget about uncompromising the grand jury. That's the underlying issue. Kate's role in handling evidence related to the grand jury that Tully submitted with Mello and whatever. That's not this. Procedurally, you cannot just be like, oh, well, we know Kate helped with the October 2023 indictments or whenever they got bound over December, but we just won't say anything about that. We just won't say anything. You cannot do that. And then it makes it worse when you're like, oh, we'll just no-pross the cases where Kate may come up. Bro, this is all for Kate. This is all for Kate. I'm sorry. This is all for Kate Peter. Oh my God. We need a good judge. I don't know who this new judge is. I know his name. I read it at the top, but I don't know who he is. We need a really, really good judge. Because that judge is going to have to make some really tough calls. And this is very bad for the state. This is like perjury level bad. I don't know. Is that how it works? Like, this is we're bordering in some of these misstatements. Forget about the consequence Forget about the consequence to the legal argument if new factual information comes out that undercuts a core pillar of your argument. Setting that aside, we are bordering on almost intentional misstatements of fact here. There's a little room on some of them for misunderstandings, but we are getting damn near close to intentional misrepresentations of material facts. And this isn't to help Jen McCabe, folks. No. I read that whole thing. This is to help Kate Peter. Oh my God. I'm very uncomfortable with a lot of this. I mean, first, they're fucked. Okay, so Bradel is very good, but he's a Massachusetts criminal defense attorney. He would look at a lot of this shit and tear them apart, all right? But you throw Betterow in there, Betterow knows this factual record probably as good as I do. We probably know different things. But my point is he knows it, and he's a constitutional lawyer. He's gonna rip this thing apart. I want to talk to him. Somebody let me interview Betterow about this. Bro, he is going to rip this thing apart. This isn't even a close call. It's not like, oh, I know some of you think, you really want Aiden to be charged, so this is close. Like, here's some arguments for the state. No, it's not close. This is the most... How do you write a fucking motion as the state, as a prosecutor, that damns your own case? What the fuck? And to do it to help Kate Peter. Why? Oh, they're so boned. Yeah, it's a motion response. So I don't think there's actually an affidavit in this. There are affidavits referenced JI5, but I don't think he submitted. Oh, fuck, he did. Cosgrove submitted an affidavit. It's just under seal, so we can't see it. All right. What the fuck, man? I'm so uncomfortable and upset, and I see it all exactly now. We need to trace out a little bit more who exactly was working for Kate Peter, who was a mole. But this motion tells me everything, bro. Like, oh my God, they spared no expense, and they fucked up too. You're gonna have the best lawyer in the fucking world. You can't predict the future. Oh, this is wild, Greer's Garden. Great to see you. Hi, 3 Clerk Monty. Yeah, the judge. Trust me. If there is a judge, I believe the judge in this case has integrity, who comes on and sees this. Oh my God, it is going to be. This is not even in the realm of. Like, what is it when you do like a voir dire challenge to a witness? I forget the name of that. Lumen Martin hearing? No, that's something else. That's when you plead the fifth. I remember that for the Kearney hearing. What was the one with Dr. What was her name? Dr. Russell. They did some kind of motion hearing where they inquired of her, and it was to determine her competency as an expert under 7.1 or whatever. And that was a close call, okay, when you're interpreting whether or not someone is qualified to be an expert witness and render opinions on certain areas. That's always a close call. This is not a close call, all right? Like, this is... You can't make these kind of legal arguments and have it come out that your material facts are wrong or that you're making misrepresentations. You can't. You're already on such shaky ground with these arguments because they're not good arguments, all right? Like, he's wrong about a lot of this stuff on the facts about Kate Peters' involvement, the extent of it. We're not dealing with the issue of, like, was Kate Peters sending innocuous material. We're dealing with the question of whether she had agency as a government actor, all right? Well, he won't, or what you're saying. No, JI5, I disagree. I think this was written They missed the filing deadline. New information came out. They had no choice but to go with what they had. They didn't have time to edit this. This was due like 6 days ago. They wrote this. Cosgrove wrote this. All the new information came out countering everything, and they just said, all right, it's already written, it's due. They had probably had meetings about it, which explains the leave to file this late. You realize Cosgrove's not even guaranteed to get this heard. Cosgrove missed the deadline. He had to file a motion for leave to file late. I think they had to have a meeting and decide whether or not they were going to file this, notwithstanding the new information. This was Cosgrove must be at the end of his career. I'm telling you, you can't get past this. You can't. Ethically, I don't even want to begin the analysis, but just on the merits, this is going to be so bad. Unless that judge is in the bag, I don't think so. I have no reason to believe that. But I'm telling you, this is incredible. It's simply incredible because, again, Betterow already did a supplemental affidavit that was filed before this thing even got filed. That supplemental affidavit alone undercuts like 90% of the most important part of Cosgrove's argument about Kate Peters' involvement in the handling of evidence related to the 2023 indictments. And folks don't understand, those were handed up in December of 2023, which was simultaneous with the start of the grand jury for the charges that got handed up in April or February or March, whatever it was, of 2024 against Aiden. Those 2024 indictments are now dismissed or null pros. The factual record ties it all together. Kate Peter was never not involved. And now Cosgrove's going to have to go in there and be like, oh, you know, Judge, well, I guess Kate Peter was involved in the 2023 cases. Okay, well, if you're a judge who read this, you're immediately going to say, but wait, your entire argument was that you don't even foresee her being a witness in the 2023 cases, so her contact with the DA or her bias has nothing to do with the integrity of the grand jury proceedings. Was she or was she not involved with the 2023 grand jury proceedings? If she was, then that's a material issue, and clearly you told me in your motion, Mr. Cosgrove, that there was no involvement in this case, the 2023 indictments for Ms. Peter, that would lead you to need to call Ms. Peter as a government witness. And now I see this email from Kate Peter to Ken Mello saying, per our conversation, X, Y, and Z about a legal strategy. About the whatever timing it was. It was in December, maybe earlier. Really? Coincidental? Not coincidental? Nonsense. Nonsense. This is bad. I could stand here all day and tell you how bad it is, but this is going in a way I did not foresee at all. And that's why Kate Peter and all her crew are so pissed at Lindsey. Clearly, they were going to try to mislead the court. You can't mislead the court. That's naughty. That is, somebody get Auntie Deb. Auntie Deb, Kate Peter's been being naughty. Her and the Norfolk DA were trying to mislead the court. Naughty, naughty. Yes, JI5, it was put before the court in Betterow's supplemental affidavit, which indeed is evidence. It also included the contacts between Kate Peter and Ken Mello related to the 2023 cases that are now at issue, and that came out in the last week. It was filed. We've reviewed it previously on stream. Okay, so maybe what we'll do is on Friday we'll read both of these back to back. We're not doing it now. I got to go eat lunch. I got to go do things. I have a life. But I'm kidding. You all are so fun to spend time with. But how about that? How about that? That is some crazy shit. I finally put it all together. Listen, it's kind of Occam's razor if you think about it. Like, of course it's Kate Peter. But to see it so blatantly. And the nice part is I would be a lot more incredulous if they were just arguing this shit. And then I was like, oh, you don't understand, folks. You don't understand. You got to believe me. There's this, this, and this. No, Betterow also already fucking sandbagged him. So I'm like, oh, this is going to be a fucking shit show. So the Betterow put an supplement. So JI5. Betterow submitted a supplemental affidavit. In the supplemental affidavit was reference to the evidence the Kearney defense obtained related to Kate Peter talking to Ken Mello. There's no affidavit about that. Betterow himself wrote the affidavit, which is under penalties of perjury, and attested to receiving the evidence, thus submitting it into the record through the affidavit. So it's not just Betterow saying something. He's saying, I obtained this piece of evidence. I'm attesting to it in an affidavit. Here's the evidence. There's no second affidavit attesting to the evidence. They don't need to do that. They have the actual email. All Betterow needs to do is attach it and then put in an affidavit that he got the evidence. That's the evidence. It's Kate Peter's own email. It's not someone saying, I heard Kate Peter did this, or someone told me Kate Peter did this. No, it's the email. So it's in the record. Michigan Meg says, hey, Grant, I'm just late, but I just printed the motion to read it myself. I'll have to rewind so I can hear your analysis. Yes, Michigan Meg, you're only about 20 minutes into the analysis, so you go watch that DVR as you're reading along. It's 26 pages, and I'm pleased to tell you, you don't actually have to, I mean, you should read it, but it's mooted. As much as this talks about the section of Mello's, about Mello being mooted, that's not even really that relevant. Mello's clearly sick, but that's a whole different story. It's related to, I think Ken Mello has cancer. So that's another thing, folks. Get mad at all the people you want. Like, Ken Mello definitely has cancer. So just keep that in mind, right? Let's just try to keep that in mind. The other thing that's going on is, and I say that because I remember being at a hearing like a year ago, and one of the Turtle Riders who knew something about Ken Mello's family was like, hey, like, I don't attribute this to me. They didn't say I couldn't tell people. I just wanted to let you know Ken does have cancer. You know, I know his family, and I don't want to say this publicly. They didn't want to, like, look like they were defending him, but they also were like, I don't care, I'm telling you. They were like, Grant, that's why I'm telling you. I want people to know, but don't tell them it was me who told them. And that's my right. I have a right to do that. But anyway, one of the Turtle Riders was like, no, he really has cancer. So if even someone who was a Turtle Rider was telling me Ken Mello had cancer like a year ago, he's definitely sick. Let's keep that in mind. But my point is, when you read through this, what you'll end up seeing is that it is just incredible, the lengths that folks went here to protect Kate Peter. I don't understand it. I am absolutely baffled. JI5, I think it was an attorney can file an affidavit. Correct. Yes, JI5. Betterow's supplemental affidavit contains evidence that contradicts Cosgrove's response to TB's motion, but Cosgrove's response was still filed, nonetheless, a late file, indeed, knowing that there was evidence. I can't get into Cosgrove's head and be like, I know that he read Betterow's supplemental affidavit before filing this. I don't know. Maybe he did, maybe he didn't. I would imagine if he's doing his job, he did, but I can't confirm that. I don't talk to the dude. But the point is, yes, notwithstanding whether or not Cosgrove knew about Betterow's supplemental affidavit, Cosgrove filed this document, which was contradicted by a document already filed with evidence. It's the craziest thing. It's like, I don't even know how to explain it. Like, I get there's some legal nuance to it. I'm not a lawyer. There's not legal advice. So you have to understand the procedure of it all to see how bad it is. And now I had moments when I was reading through this when I was like, oh, damn it. This is why lawyers are the way they are. Because this crazy shit happens. And then you want to be like, don't you see how crazy this is? But then you remember you have to translate it like 4 steps for people. Because you're like, oh, like to someone who's trained, I'm not a lawyer, this is not legal advice. To someone who's trained, when you're seeing this stuff in emotion, you're reading it differently than someone who's a layperson. You're reading it like with the rules in mind. That's the best way I can explain it. Like every sentence I read, I have this like index of rules that I'm checking it against. So like I have like the discovery rules. I have the rules of criminal procedure. I have all the cases that interpret those different rules. I'm thinking about all of that. So every sentence you put in a document, I'm cross-referencing against, did you violate this rule? Did you violate this rule? Did you break this rule? Did you conform with the obligations under this rule? What about the interpretation of the rule? What about the update to the rule? Are the cases that you're citing in line with the newest version of the rule? Are you citing good law? Did you shepherdize this? Are you actually talking about the material facts? And then that's one component of it. But then to take it to sort of the larger picture here, you then can inductively think about the strategy when you realize this whole motion is about Kate Peter. You kind of strip away some of the legalese and the performative Oscar Wilde quotes and the 5 redundant references to the movie Casablanca. Cosgrove must really I can see Cosgrove now sitting there watching Casablanca. Listen, I love the damn movie. Vultures everywhere. You know what I'm saying? But it's not apropos to... I am insulted by how he referenced Casablanca, because he was like, Kate Peter may have been sending Brian Tully, it may as well have been stuff about Casablanca. No, bro, that is a terrible analogy. Don't degrade one of my favorite films. It's not as good as Being There from 1970 whatever involving Peter Sellers. It's not as good It's not as good as some of the Kubrickian canon. But if you're going to invoke Casablanca, the film that got America through the war, my word, Mr. Cosgrove, the least you can do is use it in a manner that involves some type of literary flexing. And saying it 5 times in a row just to be like, okay, Peter could have been sending something innocuous is not good enough. If you're going to use a film for that, use something worthy of Kate Peter like Shrek. Say, Kate Peter was sending Brian Tully clips of the movie Shrek. And, let's read the sentence and replace Casablanca with Shrek, actually, and let's see how it sounds. That's why people turn in, I'm telling you. Forget about erudite commentary from a lay towel. No, you want to hear me replace the Casablanca sentence with the word Shrek before I go eat lunch. Yes, this is what the people want to hear. Casablanca. We're calling it Casablanca. All right, hold on. We got to find the Casablanca part. This is how people in law school talk, too. They're like, oh, you know the part of the opinion about Casablanca? That's the Casablanca part. You got to have a shortcut. We're changing every reference to the word Casablanca to Shrek, and then I'm going to read the sentence again, just because fuck Kate Peter. I don't trust Obach's motives per se, but she really doesn't like Kate Peter, at least ostensibly. She makes a lot of funny posts about her. All right, where's the Casablanca part? Please just get me the Casablanca part. The fact that there is a Casablanca part, I think he italicized the word Casablanca too. I really appreciated that. That was a nice stylistic touch. But at a certain point, I was like, sir, how many times can you reference the movie Casablanca in a single paragraph? Were you doing a marathon of Casablanca that weekend? Were you really thinking about the way that Northern Africa played into the tension between Free France and the Allies? Oh, here we go. All right, okay. It's right here on page 19. So we are going to who plays Shrek? Hold on. Who voices the character of Mike Myers. Okay, ready? Here we go. For example, if someone sends an unsolicited email saying that a defendant looks a lot like Mike Myers and attaches a link to Shrek, is it sufficient simply to save the email, or must the Commonwealth download and preserve a copy of Shrek? Does the content of Shrek constitute part of the statement of the witness, or is the statement simply her own words? Or her own words and the fact of her attaching Shrek, irrespective of the film's actual content? When the link goes dead without any action by the Commonwealth, has the Commonwealth lost evidence or destroyed it? Come on! This is outrageous! It's outrageous! Fucking outrageous. First of all, they weren't talking about Casablanca, bro. What, they slipped, fell, and then they weren't talking about the case. They were just watching Casablanca. And then they kept slipping and leaked the phone extraction. Oh, yes, they were just having a great weekend at the movies, learning about American history and the pantheon of domestic film production. And they chose Casablanca as the movie. It was a complete happenstance, Judge. You don't understand. Kate Peter, who's Kate Peter? She's clearly an informant about Casablanca. Yes, the Norfolk DA was recruiting people to go around with their Discord operatives to learn about the movie Casablanca so Kate could send summaries to Brian Tully. I put it all together. That's it. I have put it all together. Write it down. Ladies and gentlemen, write it down. Tell your friends. It all makes sense. Yep, no, it was a complete misunderstanding. Kate Peter was just helping the Norfolk DA learn about the movie Casablanca. Brian Tully needed summaries. He didn't understand it. It was so complex they had to bring in Robert Cosgrove. There you go. All right, laid out. Listen, call that quantum epsilon dolorum, all right? Point stated as proven, all right? Put me in the towel history books. I have thus proven it. Yep, that's it. That's the explanation. Oh, yeah, and then, of course, he made a fucking typo. Look at this. He's like, why would Kate ever send exculpatory material to Tully? Bro, the argument is that she sent fucking evidence of her bias. The other thing is, Cosgrove calls it fexculpatory. Now, I don't know what fexculpatory material is. I was a little bit worried where he was going with that Latin root there. I was like, oh no, that can't be evidence involving that, right? But there's a little X in there, so I'm hoping it's not that root, you know? It took 70 days for Cosgrove to watch Casablanca. Oh, all right, listen. Michigan Megs, you definitely earn a wrench for that. I understand. See, what Cosgrove meant to say at the end of his filing regarding why he was late is he was trying to watch Casablanca, but it took him a long time because he had to keep pausing and taking notes so he could understand why Brian Tully was assigning Kate Peter to watch the movie and send him summaries. Absolutely innocuous. They all just love Casablanca and Humphrey Bogart and that wonderful song, what is it? As Time Goes By. You can't hate on that movie. It's a really good movie with a redemption arc, but you got to think of yourself from the perspective of, does it make sense? You got to think of it from the perspective of, does it make sense? All right, that Brian Tully and Kate Peter were emailing about the movie Casablanca, or does it make sense that Brian Tully and Kate Peter were emailing about Kate Peter's role as a PI involving the Aidan Kearney investigation? If you think the latter is more likely, then the Commonwealth's going to lose this motion. If you think Brian Tully and Kate Peter were just talking about Casablanca with Ken Mello, then the Commonwealth's going to win the motion. All right? That's the most basic that I can make it. Now, I don't think a lot of you think that it was about Casablanca. That's not what they were talking about. Do you know how I know that? Because immediately after this Casablanca, we're calling it the Casablanca motion. Immediately after the Casablanca motion gets filed, evidence comes out that Kate Peter and Brian Tully and Ken Mello weren't fucking talking about Casablanca. Now do you understand why it is serendipitous? It is fate manifest. Democracy. You want to talk about democracy manifest? One, I want some chicken. Two, this is democracy manifest. All right. My name is Grant Smith Ellis. Thank you for watching. Did you find that informative, insightful? Do we have questions? Let's open a time for questions. All right. We have 10 minutes for questions. I'm ending this at noon. That gives me a little bit of time for me to eat before I got to go do towel things. So let's take questions. If you want to support the stream, you know exactly how to do that. Did I drop the donation links earlier? I think I did. If I didn't, I'll drop them again now. If you learned a lot today, feel free to support independent journalism. I assure you, Kate Peter and her people are mocking me very hard right now, trying to take away a lot of my ability to sustain myself. I think it is because I'm onto it. All right. And I think a lot of what I've said is bearing truth. I didn't want to say this because I wanted to get clout or resources. I wanted to survive long enough to tell this story. And because of some of you, I've been able to do that. So if you want to help me get a nice little lunch, get some calories in me before I go over to do my towel work, I'm going to try to work a few hours today. There you go, being a productive member of society. You can find the donation links down there. Obviously, it's a public information service and designed to educate, inform, and entertain the wider public. We use entertainment as a hook here in order to engender, coach, and public discourse and ward off the usurpation of our representative forms of government worldwide. You don't see a lot of independent public information services anymore, and you get everything on this channel, from court coverage to document coverage to analysis to regulatory coverage to breaking news and more. And if that's the kind of thing you want to see continue, then it's viewers like you who make it possible. Yes, I may have learned that from PBS, but the point remains the same. If you don't want to see sponsors, which I don't have, if you don't want to see shadow networks of control impacting what you see on your screen, the best way to help Little Towel is to be the change you want to see. But yeah, you got to think kind of like the Comey indictment getting dismissed. If someone has a question about the nature of the Odell or McCarthy standard or DiBenedetto standard, you'd have to really think about the nature of the prejudice. So it's not just was there prosecutorial misconduct or something, it's did it impact the fairness of the process. And at that point, it's not just what was Kate Peter doing. You can get over that. did the Norfolk DA over 2 years try to keep that from the public and the defendant in the court. That you can't get over. Ball game. I don't mind sponsors if they're like a good family-owned company. Yeah, I would consider it, by the way, Nunya. Like, if people have some ideas, or if you're out there and you own a company and you want to see your logo up on the screen, you can't have editorial control, but I would absolutely be interested in highlighting you for my platforms. I think we're at like 100 million plus views per year total and impressions over all the platforms. It might actually be 100 million plus just on X, at least over the past 18 months, probably like 140 million. And then on Instagram, it's a lot now. It's like 100,000 a month. And then on LinkedIn, which is really hard to get traction on, it's like 1 million a year or something. I don't know. The point is, a lot of people are reading what I'm reading. I think we're in like what I'm writing and saying, or seeing what I'm producing. I think we're in like 156 countries as well. I think most of the viewership is in the United States, but we have a lot of people in the UK, Australia. There's different marketing opportunities, I suppose. It's about 74% women that watch the program, 26% men. I don't think any of you are under the age of 18. I don't even think there's anyone under 24 that watches, according to the analytics. Most of you are between 24, 48. Some of you are older, but yeah, it's an interesting crowd. Alicia Ricci says, "You are very smart, Grant. I went through NCDAO corruption in 2023. They go after vulnerable women. To protect their CIs, I need help writing an affidavit and will pay well." Well, unfortunately, I'm not able to do that. I wish I was at that point. I'm just a little towel. But if anyone sees the call for help there, it's definitely in the chat. And by the way, I totally believe that the Norfolk DA is not going to run for re-election, and that it will be Adam Deutsch who takes that position. Michigan Megs, yes, the Cash App is # Grant Smith Ellis. Nunya's like, does that mean I'm an elder towel? Yes, Nunya. You are not just an elder towel. You are the captain of the good ship Bodie McBoatface. I'm a little bit confused as to why you don't want it to be called McTowelface, but, you know, you're the captain of the ship. Nancy, you are not a boomer. You are a super towel. You can be a boomer and a super towel, but Nancy is wonderful. You're all wonderful. We had a good time today. I'm sorry we didn't get to play trivia. I did not expect a 26-page motion. I did not expect it to have that many reverberations, and I need to go eat my lunch. So, but that said, I'm going to keep taking your questions. I promised you 5 more minutes. So before I do my outro, which, by the way, you know how we're going to do it, I end the same way every time, and we're not going to do that till 12. So you got 5 minutes. Oh, somebody sent a donation. Oh, God bless you. Thank you so much for your support, Michigan Megs. Casablanca, that was indeed a wonderful part of today's motion, even though maybe it didn't make the point that Robert Cosgrove thought that it was going to make. Now I have mental images of Brian Tully and Kate Peter watching Casablanca and then writing reports for it and then filing those with the state police. Clearly a good use of our taxpayer resources. Happy Thanksgiving indeed. You did, Michigan Megs. God bless you. I actually saw that come in on my phone as you said it because I was looking down at the comments and seeing what questions came in. Nancy from the 508 says, happy Thanksgiving to everyone. Nunya says, gobble, gobble. I think Nunya has turned from a ship captain into a turkey. Nobody tell the various animals involved in this stream they might eat Nunya. Ralph, it was great to see you. Hold on. I'm getting Pete Bunny Towel. Ralph, it was great to see you, my dear friend. I've always been a fan of your wonderful username. All right, last call for questions. Towel definitely wants to go eat, and then he's going to go be a productive member of society. All right, last call for questions. Last call. All right, I'm going to my outro, but if I see only during this 1 week every year is Nunya turkey. Oh, by the way, did you know you can vote on pardoning the White House turkey? They put out an app. I don't know which one I want pardoned. Can we pardon them both? As long as the one who is not pardoned gets to go live on like a big farm somewhere, we just can't kill the one that doesn't get pardoned. I know we have to kill some of the turkeys, but I just don't want to actually be responsible for picking a turkey and the other one dies. I just want him to go live on a farm Maybe it's a female turkey? What's the difference between a male and female? Do you call a male and a female turkey a turkey? Or are they one of those things where, like, you call a male one thing and a female the other? I have no idea. I don't know anything about turkeys. Pete Bunny Towel is also baffled. Normally he can help me, but he is an herbivore, and he says he's repulsed by the thought of eating another animal. JF5 says, Happy Thanksgiving, Grant and everyone. Nunya says, I think the president should pardon 3 turkeys. Well, Nunya, will make you the president, then you can pardon all the turkeys. I'm not necessarily sure that pardoning all the turkeys is a good idea. What if they become an invasive species? Do you know how many turkeys just wander around the streets around here? You go around, all of a sudden it's a little turkey on the corner, and I beep at it, and I'm like, are you sure you should be this comfortable and conditioned around humans? So I try to yell at the turkeys, not in a mean way, just kind of telling them, like, I'm a human. I don't think they really understand. Needless to say, if you followed me around for a day, you'd see some very funny things. Mostly me, like, looking at animals. And then I'm sure there's other things that happen. Anyway, my name's Grant Smith Ellis. I think we can do our closing. Michigan Megs, you have a great day as well. All right, so if you've never been here before, I like to close the stream the same way every time. If you benefited from today, if you learned something today, I'm going to say there's a way you can pay it forward. JI5 would like to tell us, though, that they would pardon all the turkeys. They are a vegetarian. JI5, Pete Bunny Towel is jumping up and down. He's so happy he found a fellow vegetarian. He would like to ask you if you would like to join his club. It's called the Pete Bunny Club for the Prevention of Cruelty to Turkeys. What? All right. Anyway, he's pleased with you, JI5. Nancy says the turkeys are all over Worcester. 3 Clerk Monty, final question. You got it in before the buzzer. Thoughts on same judge for 1, 2013 WB trial, 2, Farwell's case, 3, matters regarding Proctor TUI material, KR versus everyone. Oh. Well, first of all, what's the Whitey Bulger trial? Oh, wow, it's the same judge? Is it Judge Casper? It's got to be a senior judge, probably, if they were around for everything. There's probably something to the fact that they're all being tried together, or by the same judge, though. Very good question, 3 Clerk Monty, though. Very good question. I appreciate it. We'll keep an eye on that for sure. The federal cases related to those materials all being tried by the same judge does have some relevance. I don't know what it is. I think it's Judge Casper, but I don't remember, so don't quote me on that. Yes, Alicia, I agree. All right. Nunya is curious about that federal judge. I am as well. All right, so my name's Grant Smith Elvis. Let's close. I got to go eat. Traditional closing. Oh, first of all, let me just say hi to people in the chat. We had Nunya, 3 Clerk Monty, Alicia, JI5, Nancy from the 508, Michigan Megs. It was great to see you. Holy Ralph Male Empire. Again, Captain of the good ship Nunya. Michigan Megs, it was great to see you. Who else popped in here? I saw JI5. Greer's Garden, it was good to see you. Nicola Cox, our dear friend who I initially thought was from Scotland, who's actually from London. Then I found out it was another Nicola who was from Scotland. So what are you going to do? Young Black Economist, thank you so much for popping in. Had a good time chatting with you today. Really appreciate your insights. Let's talk about the Federal Reserve sometime. Lauren M., thank you for popping in the chat. Who else do we have here? Bunny was here. Bunny got through her Thanksgiving shopping. You do it, Bunny. Absolutely love it. Hello, Ducks. It was good to see you. Tanya Vincent, my dear friend, you believe whatever it is your heart believes. We'll see how history plays out. God bless you for stopping by. Christina, my friend, it was good to see you. Always appreciate your compassionate discussion. Very good to have you. You as well. Believe whatever you want to believe. The facts will play out as they do, and we'll still be here talking. Auntie Bev's alongside. God bless you. Such a handsome turkey towel. I am a little handsome. All right. Allie, Towel, and Rue were here earlier. Sorry we didn't get to play trivia. I had emotion. I knew it would come in. I knew it was going to be big, and it was. Troy was here. Good to see you, Troy. LS was here. Good to see you, my dear friend. Oh, we had a lot of towels popping in and saying hello. And, of course, Nancy was here as well. Marvin Hagler asks, who will win, Belmont or Watertown? Isn't Belmont, first, I only really track BC, but Belmont football is just notoriously terrible, so I say go with Watertown. I probably should vote for Belmont, seeing as I'm from Belmont, but we were pretty terrible when I played as well, so. All right, towel friends. But yes, Marvin Hagler, thank you so much for stopping into the stream. Let me end the same way I end every day. Oh, 3 Clerk Monty, I saw you in there as well. If you benefited from today, if you learned something today, if you liked this stream, if you found it informative, here's how I really want you to pay it forward. Look for reasons to do small acts of service and kindness, ladies and gentlemen. It can be something as simple as donating to our homeless veterans. I truly believe there should not be one veteran in the United States of America who is homeless against their will. Shame on the scar on the face of the country. Shame on all of us. They want to go live in the woods. That's fine. We're not going to stop them. Not one veteran should be homeless against their will. You can help by donating to charities that support our homeless veterans. Second, what if you want to support animals like Pete Bunny Towel? You can donate to an animal shelter run by veterans. Maybe it's an animal charity that trains service dogs for veterans. Either way, you can help animals and help veterans. Now, what if you want to help animals and you can't find a service shelter run by veterans? That's okay. You can donate to an animal shelter or find another way to do so. That's a great way to pay it forward this holiday season. But it can also be something like donating to The Big Issue if you're in the UK. That's a great charity that helps populations experiencing homelessness get back up on their feet. Nicola, oh, I'm so sorry. Yes, so you can watch the replay. You absolutely can join the replay crew for this one. You'll find a lot of the information, I think, to have been helpful. Sorry we can't do a full day stream today. I'm actually going to do some work later today, hopefully. So there you go, being productive, and I appreciate it. Where I left off, though, was you can donate to The Big Issue in the UK. It's a great way to help populations experiencing homelessness. But it can really be something as simple as waving at a friend or family member, waving at someone on the street, saying hello to a friend or family member you haven't heard from in a while, or even donating 200 tomato plants like Francis Frutrell did one time and having them designated as honorary towels forevermore. Yes, in that way, ladies and gentlemen, I believe we can change up the current realpolitik from one centered on preserving, expanding, and demonstrating our power to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness based in unconditional love. I believe it's possible because of you all, ladies and gentlemen, and I think we'll bring about, through those ripples of kindness, a new digital epic defined by Aquarius the Water Bearer standing tall and carrying a towel. My name is Grant Smith Ellis. I'm hungry. Nicola, it was great to be able to add you with a towel wrench. Nicola says, hi, Grant. Good job with law school. UK has a Dogs Trust charity. I love it, Nicola. You just either send me a message on Twitter or find me. You let me know the name of that charity, and I would be happy to share the name of it at the end of every stream. That would mean a lot to me. But yes, Towel Friends on the X. It's Thanksgiving in the U.S. Even if you don't celebrate Thanksgiving wherever you are, happy Thanksgiving from me and Pete Bunny Towel to you. He's going to eat a lot of lettuce. I'm going to eat some turkey. I hope you all have a wonderful time with whoever it is that you spend the day with. If you need someone to talk to tomorrow, you just reach out to me. If I see the message, I'll respond. You know where to find me, Instagram, Twitter, X, whatever it may be, all Grant Smith Ellis. Or you can email grantsmithellis@gmail.com, and I'll find you as well. I really appreciate the time we got to spend together today. We'll see each other probably Friday, if not Friday. I think Friday's looking good. And I'm looking forward to that. So I'll have more updates, I'm sure. If something big happens, I doubt it. Between now and Friday, you'll see me. If not, I will see you Friday. Hopefully nothing will happen on the holiday. It's not a holiday for people not in the U.S., but it's a holiday here. Happy Thanksgiving indeed. So, Towel Friends on the X, God bless you. Be well. Enjoy the beginning of this holiday season. Merry almost Christmas. Get ready for the Christmas music. It's coming, and no one's going to stop it. Pete Bunny Towel's very excited. My name's Grant Smith Ellis. Be well, Towel Friends on the X. Enjoy the rest of your Wednesday. Happy Thanksgiving Eve. Until we see each other soon, Towel loves you very much. Towel Friends on the YouTube, you got a few minutes. Towel Friends on the X got a few minutes at the beginning. You get a few minutes extra at the end. Let me go eat my lunch. I'm so grateful for you all coming into the holiday season. God bless you for all your support, your compassion, your discussion, all that you do for each other and for Little Towel. You make the world a little bit of a brighter place, and hopefully this little corner of it is setting the tone. So I appreciate every single one of you. Thank you for watching with me today. Be well, be safe. Me and Pete Bunny Towel are going to have a great holiday. You do as well. God bless you. My name is Grant Smith Ellis. Towel loves you all very much. thank you for your support. Until we see each other on Friday, be well. I'm going to get a cheeseburger.